Mic test. Great, good morning and welcome back to docket number 24-1004. Before we start with our panel, are there administrative matters?
Good morning, Commissioners. Over the weekend, Mr. Hurwitz was able to locate the information responsive to readings N, Q, U, and V. If we'd like to read those in at your convenience.
Very good, Mr. Hurwitz.
Read-in N sought information regarding the guidelines for sign-on payments to certain employees, which upon reflection, we have provided as OCC 861 confidential attachment 1. Read-in Q sought information regarding the rating of certain employees that were involuntarily separated from the company. We've subsequently been able to locate that information as well. In 2022, the referenced attachment identified 2 involuntary separations. One of those employees was rated partially competent. The other was a union employee and accordingly had no such rating. In 2023, there were 4 separations. All 4 were for union employees with no such rating. 2024, there were 2 such separations. One was a union employee, the other was rated fully competent. Read-in U sought information regarding incentive compensation paid in 2023 and 2024. The company provided information regarding incentive compensation payments, i.e. UI total level cash payments in response to OCC 288, Schedule C 3.16D of our initially filed revenue requirement provided 2023 UI distribution incentive compensation expense. We were subsequently able to identify the 2024 equivalent of that number, which is $2.144 million. Read-in V sought information regarding an element of the company's incentive compensation plan related to the targets of the regulatory business area. The UIL company regulatory business area targets include targets set as per the Avangrid Networks Group monthly KPI report and include targets for UI as well as CNG, SCG, and BGC. Targets include the following areas: service level, i.e. contact transactional satisfaction survey, average time and seconds to answer a call, public service complaints, service appointments, i.e. percent of service calls met, uncollectibles, i.e. customer service bad debt write-offs, SAFE, SADI, vegetation management, leak-prone pipe replacement, excavation damages, and emergency response. The achievement is either a hit or a miss for each target. In 2023, there were 39 targets and 5 were missed. Therefore, the attainment was 87% or 34 out of 39 targets.
Thank you. Anything further from
No additional administrative matters from us.
Thank you. Attorney Wheel.
Chairman Tom Wheel from the OCC. I just had an update on the kind of a scheduling update. I wanted to let the authority know that we had reserved 2.5 hours for the rate design panel, which is on page 15, which is the next panel after this one. We expect that we'll have significantly less than that, maybe 1 hour for that panel, which is good news. But I did want to also remind the authority that our witness on page 16 is not going to be available until tomorrow morning. And then also remind the authority the less good news that I have significantly more cross-examination for the poll attachments panel than we indicated on page 18. So I just wanted to update everybody with that. Thank you.
Thank you, sir. Anything further? All right, seeing none, Attorney Vaughn, if you want to introduce your witness panel, please.
Thank you. Good morning. I'd ask the panel members, beginning with Mr. Hurwitz, to each please state your full names and positions for the record.
Jacob Hurwitz, Senior Director of Revenue Requirements, here on behalf of UI.
Steve Mullen, Director of Environmental Remediation for Avangrid Service Company.
William Burgess, Project Manager, Remediation, here on behalf of United Illuminating.
Thank you. And Mr. Hurwitz was previously sworn and adopted his pre-filed materials.
Very good. Mr. Mullen, Mr. Burgess, if you could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
I do.
Thank you. Attorney Vaughn.
Mr. Mullen and Mr. Burgess, as part of your preparation for this docket, did you provide pre-filed direct and rebuttal testimony and exhibits which were marked as exhibits UI ERP1 through UI ERP8 and exhibit UI rebuttal 1 and 5?
Yes.
And did you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
And do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
I do have one small typo. Page 1, line 17. It has to do with, I was the manager, it states I was a manager of the remediation group from 2019 through 22. It's actually 2018, typo in 2019.
And that would be to exhibit UI ERP1.
That's correct.
Thank you. And subject to that update, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
And thank you and good morning. Before we open up these witnesses for cross-examination and to streamline the proceedings and hopefully avoid and limit interruption, United Illuminating is asserting a standing objection on the record as to all questions relating to claims of the company's compliance or non-compliance with the partial consent order, which is referred to as the PCO, that was entered into between Deep and the company in 2016 regarding the investigation and remediation of the former English Station site. And as Pura knows, Deep can bring and has brought enforcement proceedings against the company, raising claims of alleged non-compliance with the PCO. In that case, which is pending in Superior Court, is the proper forum in which to litigate these issues relating to compliance with the PCO. And the company's view, which it has presented in its pending appeal of Pura's decision in its previous rate case in docket 22-08-08, is that Pura has no jurisdiction to impose rate penalties based on its assessment of UI's environmental remediation relating to a property that UI sold and removed from base distribution rates decades ago. And further, as the company has stated in its pre-filed testimony, the company is not seeking rate recovery for costs it has incurred in connection with investigation and remediation activities under the PCO. So on that basis, and to avoid undue interruption and delay of the proceedings, UI respectfully asserts a standing objection to that line of questioning. Thank you.
Okay, thank you, Attorney Hum. I think we'll note your objection for the record. I will overrule it for the record, subject to more specific objections. The company notes during cross-examination and leave the company to its briefs on the matter. So for now, we will turn to cross-examination by Deep BETP. Whomever would like to begin, please.
Good morning, Commissioners. My name is Brendan Shane. I'm the Legal Director for the Department's Environmental Quality Branch, representing the Environmental Quality Branch. I'm joined by...
Good morning, Sarah Solar, Staff Attorney on behalf of the Department of Energy and Environmental Protection.
Good morning.
Good morning.
I'd like to start by focusing my question on the time between the last rate case and this one. And in that time, the pre-file testimony indicates that the company spent about $1.1 million on remediation.
That's correct.
And I'd like to try to put that number into context. And so the partial consent order requires the company to spend at least $30 million on remediation and to refund to the state the balance if $30 million is not spent.
Is the question, have we spent the $30 million yet?
No, the question is just, is that what the PCO requires?
That's correct.
And apologies, I didn't get it out in time, but just objection with respect to what the PCO states. It states what it states, and that speaks for itself. So the objection is to the extent the witnesses are asked to interpret the PCO, that's where the objection is. Thank you.
Thank you. Okay, let me just say this back to you, Attorney Hum. So the specific objection on the record is whenever a question is inviting the witness to explain what the what the agreement says, you just want to know for the record that the agreement says what it says. Is that a fair recitation of your objection?
Yes, I think that's a fair recitation, that the agreement states what it states, and the witnesses, they're not here to interpret what it states.
Okay. All right, thank you.
And I think we would all agree that remediation of English Station is likely to cost more than $30 million.
We're still going through investigation and remediation. And I think the total number, once we get through that, given all the obstacles that we've encountered, will play out.
Okay. So I'd like to talk a little bit about how that $1.1 million was spent. Would you agree that many remedial approaches require sampling to distinguish PCBs and building materials from releases of PCBs?
Could I back up just 1 second? Sorry, it took me a minute to catch up here. When you originally asked, since the previous rate case, did you have a date in mind, or because you referenced, the company spent a certain amount since the previous rate case?
So that was the question that was asked in the interrogatory, and I believe the response was $1.1 million had been spent.
Just pulling it up here.
Do you have the interrogatory reference by chance?
Deep 3.
Okay, I have that one up. Thank you.
And so in its response, the company indicates that since March 29th, 2023, you've expended approximately $1,190,581. Is that correct?
I see that.
So to restate the previous question, you would agree that many approaches to remediation require sampling to distinguish between PCBs present in building materials from PCBs present as a result of a release or spill?
In order to make that determination of whether the PCB impacts got there as a result of a spill or were part of the manufacturing of that material that was applied or installed in a building or in another use, one way that you could try and make that determination would be through sampling.
And was any of the approximately $1.1 million spent on that type of sampling?
The approximately 1.2 million that's referenced in DEP 3, those are direct costs related to investigation and remediation activities at the English Station site, including implementing investigation and associated reporting related to the English Station plant building.
Yeah, I'm sorry, that's not exactly my question, though. My question is, was any of that money spent on sampling to distinguish whether PCBs are present because they're in building materials or as a result of releases?
Yeah, as part of that 1.2 million, we continued our investigation of the plant building, and those investigation reports that we have identified on the record here in this proceeding, those included sample results from potentially spills and releases of PCB materials, but also building materials themselves.
In very specific areas of the power station building?
In different portions of the building. Yep, yeah, because this is a large structure, 100,000 square feet approximately. It's identified in the testimony. And, just backing up, early on in the project, once the company gained access under the partial consent order to start its
evaluation and investigation of the property, it became readily apparent that the conditions of the building were not what was anticipated going into it. And the
And I-
impacts were far greater than we had anticipated. And so, the initial, the steps in the partial consent order talks about preparing a scope of study, and that includes for the plant building. But the extent of asbestos contamination inside the building, it required a lengthy interim remedial measure that had to be performed before our contractors could even get access to start the investigation work. So the decision with DEP's involvement, UI had worked with DEP, is working with DEP, continued to keep them informed of the challenges that we were encountering on the property.
I think we're wandering beyond the scope
Well,
of the question, though.
I am getting there. It's all related. The story's complicated, so I am getting there.
I appreciate that, but I'm specifically focused on sampling that occurred from that March 29th date till today. And what I believe I heard you say is that any sampling that was done during that date would have been in association with one of the reports or submissions that you've listed in the chart that's attached to your testimony. There wasn't other work done.
Sorry, could you rephrase that? What do you mean there wasn't other work done?
So in attachment 1 to interrogatory, or I'm sorry, I'm gonna get the citation wrong. RSR 212, there's a list of documents, right? And so
I'll pull that up.
So what I believe I heard you say is that any sampling that was done would have been captured in those documents. Any sample results that were required would have been captured in those documents.
Well, there's been a bunch of investigation activities on the project, including investigation results that are summarized, that have been collected on the property as part of investigating and remediating the site that would not be included in there. There are additional samples that we've collected. But, going back, the decision was made because of the condition of the building. There was going to be a delay to mobilizing to start investigating the building itself. So UI, brought this up with DEP. DEP was informed of that decision and they were on board. So the decision was made to proceed with a partial investigation that included the areas outside the building until the building could be made safe. Additionally, the decision was made that as the building was being made safe, the hazards were being removed and abated up front to break the building into smaller pieces, if you will, portions of the building for the investigation. And that would allow the project to continue on a more expedited schedule so that as we were opening up these areas of the building, providing access, we could collect samples and do investigation in certain portions.
Taking all that as context, again, I'm particularly interested in the time period since March 29th of 2023. And I still don't feel like I've gotten a clear answer. Was there sampling done during that period to distinguish between the types of PCBs present in the building?
Yes, there was sampling conducted to analyze for PCBs, and referring back to the company's response to DEP 2. This is, one response where we point to the 6 investigation summary reports that were prepared that summarize investigation results, sample results that were collected from the building. And part of that, that these reports were submitted to DEP for review between the timeframe of November 2023 all the way up until February of 2025. And these are very detailed and complex investigation reports that summarize the results of over, I believe the number is approximately 4,000 samples.
Right, but those samples were taken since the March 29th, 2023 date?
What do you mean by samples taken?
The samples were collected in that time period? Or the results were being provided in his report submitted in that time period?
Thinking back to the time frame, so in early 2023, and referencing the, under that DEP2 response, the third bullet down, the February 2024 boiler 13 concrete foundation and other sampling partial report. So based on my recollection, around that time, we were still collecting and conducting laboratory analysis of samples that were being collected from the building. I don't have the exact dates. And then the other investigation reports were to incorporate supplemental investigation reports, based on our comments and feedback from DEP. Significant supplemental investigation work was required. So those, we had submitted some earlier investigation reports for the building, and then these newer ones were to, if you call it, refresh those reports to incorporate all of the data that was collected from these various portions of the building.
Would you agree that the partial consent order requires the company to notify the department 5 days in advance of conducting sampling?
Objection calls for a contract interpretation. The PCO speaks for itself.
UI submitted the PCO as an attachment to its responses. I think it's legitimate to ask questions about what it says. If he doesn't know, he can answer that he doesn't know.
I am going to overrule the objection and allow the witness to respond as to his understanding.
I'm not a lawyer, but I understand that there is some language in the PCO that discusses notifications prior to sampling.
Do you know if any such notifications were submitted since March 29th of 2023?
Off the top of my head, I'm not aware.
Let's turn to another aspect of the remediation. I think we could all agree that the remediation requires the importation of a significant amount of fill.
As part of the remediation scope, because part of the plan is to excavate impacted material, and there's going to be voids that need to be filled in addition to bringing in material to cap that. Yes, backfill material is required.
Was any of the $1.2 million spent on purchasing that fill? Actually purchasing the fill, not costs associated with it.
Right, I'm just thinking, so as part of that report that I just referenced in the boiler 13 area, so that report was an investigation report, but that summarized results from this investigation effort that was done beneath the boiler 13 of the building. So this specific area where there was a historical release after UI's ownership as part of the previous owner. Now there was a partial salvaging activity, and there was a release of oil in that area. So and going back and forth with DEP on comments, the decision was made that supplemental investigation was required in that area. So that in order to continue that investigation that's summarized in that report I referenced, there was a significant remediation, interim remediation that had to be done. And that was around that 2022 into early 2023 timeframe. And that was removing PCB impacted material from the floor of that portion of the building and beneath it so that we could go in there and collect additional samples. And that was as far as I know, the most concentrated area of PCBs and release on the site. And so when you asked the question, I was thinking back, did we have to import fill as part of that scope? I don't believe so, subject to check. So the 1.2 million that you referenced, I don't believe so, but I'd have to check.
Okay, and so putting aside for a second the boiler 13 area, how about the rest of the site? Was any fill purchased to be spread on the rest of the site or placed on the rest of the site?
I don't believe so.
And the full $1.2 million, a significant portion of that was not spent on cleanup costs, right? $119,000 was spent on site security?
I mean, I wouldn't characterize it that way. I guess it depends what the definition of significant is in that context.
Nearly 10% of the money was spent on site security?
Excuse me. So regarding the 119,000 figure, and that was provided, I'll pull up the reference here.
I believe it's in deep 14.
Thank you. All right, so the company's response to DEP 14, we indicate that between March 29th, 2023 through February 2025, the company spent approximately 119,000 to maintain and enhance security at English Station. So that includes all the additional security measures that we put into place on the property, continuing to maintain security, coordinating with our third-party security vendor, DEP, the city, and others. So that's where that number came from.
Okay.
And then
But
the
even-
one point,
Mr. Shane, can you let him answer the question, please?
Well, it's sort of a yes or no question.
No, well, the witness is providing you an answer, and I think he can finish his response.
Okay, I'm gonna treat that as an objection and sustain and ask the witness to respond to the question, please. Finish responding, sorry.
thank you. So that's the 119,000 that was referenced regarding security. And then I believe the original question was, when I was getting there, what was the, or what, could you rephrase about the remediation and part of that 1.2 million?
Well, I think I asked whether all of the $1.2 million was spent on cleanup activities or whether a significant portion was spent on security.
Again, I can't, we may have different opinions what significant is, but
Understood.
so the 119,000 on security, and then the other activities that were performed during that time period included the boiler 13 interim remedial measure, remove that contaminated source area beneath the building. So that's part of that cost. That is a remediation scope in order to continue our investigation. And then some of the other activities that were performed that would be included in that 1.2 million are licensed environmental professional consulting fees and expenses to prepare all of these reports, to summarize results, to continue the investigation and remediation, perform oversight of that remediation scope. It includes the security and I'll pause there.
So even after spending $119,000 to increase the security or on the security of the site, there were 24 trespassing incidents since March 29th, 2023?
As provided in the company's response to DEP 12, we identified between March 29th and 2023, approximately 24 occasions where trespassers accessed the English Station site. And just to clarify, so the company maintains security of the site at a minimum that is consistent with the security measures that were in place at the time of the PCO access. So going back to 2016. Since then, we have gone above and beyond to maintain security. I'm talking about installation of fence in several different areas to prevent unauthorized trespassing, including modifications to the fencing in different areas, securing and adding to barricades on the plant building so that people cannot gain access, unauthorized people that are, in most instances, they're not walking onto the just walking onto the property through an open gate. This is cutting through, damaging, climbing over the security measures that the company or the previous owner had put in place on the property.
And 24 people were able to breach those security measures in this period.
I'd like to maybe expand a little bit. There was significant discussion in the last rate case about security. The company has always been serious about security, and we do have an obligation, PCO, to maintain it to that minimum requirement when it was handed to us, and we have done that. We've also expanded it, and as Mr. Burgess indicated, these were not trespassers just walking across the property line. They were making concerted efforts to get on the property, and we have tried to manage that security in a way that prevents people from coming on.
And, as described in the response here to DEP 12, the surveillance system that is now out there, it replaced an outdated one that was in place at the time of the company accessing the property. So it's able to identify these trespassing in real event. And as summarized here, when the surveillance system, in these instances, when and if it picks up a trespasser breaking through our security measures, unauthorized and accessing the property, even though we have all this signage and this additional security measures in place, it has automatic notifications to the police department.
Pass questioning to Sarah for a moment.
Good morning. I have a few questions related to personnel. In a response to Deep 16, it's noted that the decision-making authority for this English station project is Frank Reynolds. Is that correct? I'll let you pull it up.
Sure. So I just pulled that up. I'm familiar with the response, and the question was, the original interrogatory was asking who has final decision-making authority over the cleanup of English Station, and the response was Frank Reynolds, as president and CEO of UIL Holdings, is authorized as the decision maker on matters related to the operation of the Connecticut utilities.
And do you recall testifying at the last rate case about project sponsors? I'm sorry, I believe it was Mr. Mullen.
I do.
And when these questions were asked the last time, do you recall who was listed as the sponsors?
I don't recall that specifically right now.
Would you remember if I said, or would it sound correct to you if I said it was Frank Reynolds, Scott Mahoney, and Kenna Hagan?
Those names are familiar to me, yes.
Yes. So now looking at Deep 16, only Frank Reynolds is listed as the person who makes ultimate decisions on English Station. Do you know what has changed since that response was last given and the one in Deep 16?
I'm not sure that when I responded last year about the decision, those were folks that participate in routine meetings we have to give project updates, who I view as, kind of the sponsors, but the decision on the project is Mr. Reynolds.
And are you aware, are there any other executives besides Frank Reynolds whose approvals are necessary for this project?
I'm not personally aware.
I have a couple of questions about the project manager for this site. I believe that the project manager is now Eric Boswell. Is that correct?
That's correct.
And he has been the project manager since 2024?
I believe it was January, subject to check.
Yeah, so, and just to clarify, so Eric Boswell, and we provided this in our response, I can pull it up while we're talking here, but Eric Boswell is the lead internal project manager on the project, but we also, because this is a very technical project and it's identified in the partial consent order, as is commonly the case in Connecticut, these remediation projects have some lead and oversight by outside consulting professionals. So in this case, it's TRC, and TRC Companies has been on the project since the start of the partial consent order in 2016. So we've had from TRC a lead outside project manager since that timeframe, 2016. In addition, TRC has also been the licensed environmental professional that's been involved since 2016, helping to oversee the project, be the subject matter expert when it comes to investigation and remediation of the site.
Can you further explain then what the internal project manager's responsibilities are?
Sure. So as project managers internally here, and I've been, supporting the project since I started with the company in 2019 in a support role. I've been also the lead environmental project manager for a while on the project, and I still continue to support the project in my PM capacity. And as project managers on the internal side, our role is to coordinate between the outside professionals that are involved with implementing and overseeing the project. So that would include TRC, as the licensed environmental professional, the project manager, contractors that are involved with the project, whether it's remediation contractors or security vendors, working on the procurement side of it to put together scopes of work and RFPs for those professionals so that they can implement the scope.
And since the close of evidence in the last rate case, where we're looking at that March 29th, 2023 date, that timeframe, is it accurate to say there have been 2 internal project managers?
So both Eric Boswell and myself have been project managers on the project since that time period. Again, I started in 2019 as a project manager in a support role on the project. And then Eric Boswell came to the company sorry, I'm turning to my colleague here. It was around May of 2022 and has been involved since that period in either a support role or as a lead internal project manager.
Thank you.
I'd like to turn back to interrogatory response RSR 212 and attachment 1, which is again that table of reports that have been submitted. That table indicates that there are 4 reports that have been submitted to the department and are awaiting approval. I can list them if it's helpful. It lists an investigation report for the high pressure boiler areas, an inspection for hazardous building materials, boiler 13 concrete foundation and other sampling, partial, and a boiler 13 interim remedial measure PCB remedial action report.
I have the document up. I don't see the specific reports. There's been a lot of reports submitted on the project. I don't see exactly the line, but.
So I believe there are lines 40 to 43 of the spreadsheet.
I see those. So that starts with the inspection for hazardous building materials in the boiler 1 through 14 areas and ends with the progress reports.
It's line 40, investigation report, high pressure boiler area.
Okay.
And then to line 43, boiler 13 interim remedial measure.
I see those.
And so that table indicates that that those reports have been submitted to the department, but are awaiting approval.
So, sorry, I had to refer back to the footnotes. So looking at footnotes 8 and 9, these are partial investigation reports related to investigation work inside the building. And as I previously discussed, the decision was made with DEP input and acceptance to break up the building into portions of the building so that we can continue investigation work while all these unforeseen conditions were being dealt with. So those are partial reports, and we indicate that here in the footnotes that while the PCO, it identifies certain large buckets or steps, it doesn't specifically call out partial investigation reports. So we identified that, yes, we were waiting for DEP approval or are waiting for DEP approval, because that's consistent with the process that was followed previously on the project so that things could continue to advance while we were making the building safe for investigation. So we identified that as a footnote because while it may not be spelled out specifically, that was the approach that was accepted by DEP, because it also gives an opportunity as we prepare these summary reports for portions of the building to supply that information to DEP for review, because there's also, in the PCO and it's happened previously on this project, they could request supplemental investigation work. So that gives an opportunity to review the data to make that determination.
But there is no requirement in the PCO itself that those reports be approved.
Just objecting to the extent it's requiring a contract interpretation. The PCO speaks for itself.
Thank you. And I will overrule and ask the witness to answer the question to the best of his understanding.
Yeah, again, I'm not a lawyer, but the PCO, it doesn't say anything that individual or partial reports can't be submitted and that DEP cannot review and approve those or provide feedback on those. And that was the accepted practice on this project for the reasons that I had already identified. And so, going back and thinking about moving aside from the building, thinking about the exterior areas of the site. So I'd already discussed that the decision was made while the building was being made safe through this interim remediation and abatement, that we would do a partial scope of study and investigation of the areas outside the building. And as part of that, in communicating with DEEP and having DEP's acceptance, we submitted partial investigation reports for the soil that DEP reviewed and approved. And that allowed us to get feedback from the department, DEP, and to move on to the next stage that would begin the remedial planning process. And so these, again, these partial investigation reports, while it may not specifically call it out in the PCO that they're required, this was the accepted practice, and we have continued doing that for all the reasons I've already identified.
Commissioners, before we continue, I just want to know in the objections, council has referred to the PCO repeatedly as a contract. The PCO is not a contract. And while that's an issue that divides the parties, I don't think it needs to be litigated here. I just want to be very clear for the record that the department does not consider the PCO to be a contract. It is an order issued by the department, and don't want to be seen as accepting by not clarifying any argument the company's advancing on that front.
Okay, Attorney Shane, thank you. Attorney Hum.
Thank you. And I appreciate the distinction that Attorney Shane is making. The reason I've referred to it as a contract is because it's a partial consent order. So the consent is where the agreement comes in. So therefore, the document is an order that was entered, but it's an order by agreement of the party. So therefore, I've been referring to it as a contract. If the chair would prefer, I can refer to it as, I could just refer to it as the partial consent order in completion to make sure that there's no confusion.
Thank you. So that sounds like Attorney Hum, you're not specifically um, intending anything further by referring to it as a contract, or you are?
I'm referring to it as a form of a contract just because it's a consent, again, I won't repeat myself, for what I said before, the consent portion of it makes it an agreement. So that's why I've referred to it as a contract. But going forward, I'll just refer to it as either the PCO or the partial consent order.
Okay.
Thank you.
All right, thank you. Then I would I would appreciate the dialogue and encourage it to be referred to specifically as either the PCO or partial consent order moving forward. Thank you.
Thank you.
Attorney Shane.
And the PCO actually refers to a comprehensive report that includes the result of investigation, the evaluation of remedial alternatives, a schedule to perform the preferred remedial alternative.
And first opportunity to exercise what we just talked about, objection, the PCO speaks for itself.
And I'm sorry, I should frame the question. Are you aware that the PCO actually refers to a comprehensive report?
And I'm still going to make the same objection to the extent he's putting words in the PCO's mouth, to the extent it has a mouth. But I think, again, the objection is that the PCO speaks for itself.
Thank you. And I will note that the authority is, has the PCO in the record and will review it itself, but I'm going to continue to overrule this specific objection and direct the witness to respond based on his understanding.
So I am generally aware, again, I'm not a lawyer, that the PCO discusses a comprehensive report. And again, this is, as I've already discussed, that was under the assumption going into it that this project of this scale and this magnitude, and with all the challenges that we now know, existed at the site, in addition, I don't know if I've mentioned, but these UI doesn't own the property. These are two separate parcels. And along the way, for certain steps of the project, DEP has required that the company get the owner to sign off on certain steps. So that's all, taken time on the project.
But none of these four reports that we were just discussing are a comprehensive and thorough report. Allow me to rephrase. None of these four reports that we were discussing are the comprehensive and thorough report described in the text of the order.
And before the witnesses answer, just stating an objection for the record to the extent it's requesting the witnesses to opine on compliance with the PCO as a legal interpretation.
Okay. And I will, Attorney Shane, a response.
I'm simply requesting clarity as to whether the four reports that were just discussed and described are intended to be the comprehensive and thorough report. I'm not asking for a legal conclusion as to whether it's in compliance or not in compliance. I just want to understand what they are.
And if I may respond ever so briefly, is the question with respect to just those four reports or to other reports that are identified in that attachment to the interrogatory?
We start with just those four reports.
Oh, okay. So, so the question is, are those four reports the comprehensive report? Is that your question? Okay. And does counsel object to that rephrasing of the question?
For clarity, would you please just restate it in full so that I could hear the full context, please?
Are the four reports we were describing and discussing the comprehensive and thorough report required by the consent order?
Same objection.
Okay, I will overrule the objection and direct the witness to respond based on his understanding.
So those 4 reports, as I discussed, those are partial reports that are comprehensive in and of themselves, but they discuss investigation within portions of the building. And as I discussed previously, the decision was made early on in the project when we first got access under the partial consent order to start work out there, that in order to continue to advance the project and make progress, on an aggressive schedule, that if progress was going to be made, it needed to be divided into smaller portions so that we could continue to do work while other activities were going on to make the property safe. So that original reference to a comprehensive report, that was contemplating that everything would be done at once. And with DEP's acceptance from early on, that was not the case. That's not how it played out.
So no.
Sorry?
So no is your answer.
For clarity of the record, could you please just restate the full question in terms of, instead of just so no, just please restate what you're specifically asking him to answer?
So your answer is that those 4 reports are not the comprehensive and thorough report required by the order.
So what Mr. Burgess has indicated, that those are investigation-related reports, and those are pieces that get you to that sort of report you're referring to.
So UI has not submitted the comprehensive and thorough report required by the order.
Yeah, again, you keep ending your question with as required by the order, and I don't know that sitting here as a non-lawyer, I can interpret what is or is not required by that order.
Well, I thought we all agreed the order spoke for itself.
Yeah, but you ended your question with as required by the order.
Right, so the order requires something, and the question is whether UI has submitted it or not. I'm not characterizing what the order requires. I'm asking whether UI submitted that thing or not.
So I'm also going to assert an objection. If Mr. Shane would like to rephrase his question, I think there may be a way to ask this without asking the witnesses if it's as required by the order. But I'm restating the objection that it's asking them to state a legal conclusion.
Okay, I will sustain the objection and ask Attorney Shane to rephrase the question, please.
I'm going to refer you to the PCO, which is UI ERP 6. And I'm going to find you the exact reference, which is paragraph B1E. And that paragraph indicates that respondent shall submit for the commissioner's review and written approval a comprehensive and thorough report which, and then it lists a number of subdivisions.
You said B1E
B1E, that's correct.
on numbered page 8, PDF page 11.
I am not certain I have the exact same version in front of me that you do.
The entirety of that paragraph as I see it, and I'm just going to read this aloud, not interpret it. It reads, shall agree to the recordation and implementation of environmental land use restriction or restrictions affecting the site on the City of New Haven land records in accordance with some specific statutes and any deed notice pursuant to 40 CFR Part 761 and the RSRs as applicable.
No, I'm sorry. Let me find the correct reference. On page 30 of 64 of UI ERP 6. Beginning except as may be provided.
I see that now. Thank you.
And so the question is, the company has not submitted for the commissioner's review and written approval a comprehensive and thorough report, which, and then that lists the things and the subdivisions there.
So again, I'll just reiterate that it's more complicated. I see this language here,
I'm
but
going to
we've,
stop you there. That was very clearly a yes or no question. Got to be able to answer that question.
He's So I think, so the witness is attempting to respond to the question to provide a fulsome and thoughtful answer that's accurate with respect to the question that's being posed. If the question is confusing or can't be addressed in a simple yes or no, I think it's fair for the witness to provide that full context.
I disagree that the question is confusing. It's a yes or no question. Have you submitted the thing that the order lists?
Okay, let me start by reminding council to please direct your objections and commentary to the bench. And give me 1 moment, please, to catch up. I was still pulling up the reference here. Okay. I am going to sustain the objection. Attorney Shane, if you want to re-ask the question and remind the parties to direct their objections to the bench. And I will caution the witness that we do need a yes or no here for clarity of the record. You're welcome to explain fully your answer. But I would ask Attorney Shane to re-ask his question, please.
So referring to paragraph B1E on page 30 of 64. The order indicates that the respondent shall submit for the commissioner's review and written approval a comprehensive and thorough report. Has such comprehensive and thorough report been submitted?
No, and as discussed, we had agreed early on, while informing DEP, having meetings with DEP, getting their review and concurrence, that putting this together as one package was not feasible in a manner that would allow the project to move forward at even the pace and the amount of work that's been done currently on the project. And so the decision was made to break this section down into smaller pieces, both by areas of the site, so the plant building itself as one phase, the exterior areas outside the plant building as another phase, and then to have the information that's detailed in these next sections, including B1E, 1, 2, 3, 4, to be broken into separate sections and provided to DEP for review. So some of the individual components here, in cooperation with DEP, have been provided, specifically. And I'll point out that before, the section that you read, respondent shall submit for the commissioner's review and written approval a comprehensive and thorough report, which before that it says on or before 30 days after the approved date for the completion of the investigation. So the investigation has had to proceed and be completed if it were to move on to this larger package or larger comprehensive report that's referenced here. So for the soil, the investigation was performed, the investigation report was reviewed and approved by DEP, and then moved on to the next step to evaluate certain remedial alternatives, and then move on to the next step to start the remedial planning process. And then, I indicated that there was a separate phase that was specific to the plant building, the large former power plant structure, that because we couldn't even get in there to do our investigation until, I believe it was, a full investigation until around 2018, once the building was made safe for access to perform that investigation. Then we started that investigation, and those 6 reports that I referenced previously that were specific to the building and that were in response to scopes of study that were reviewed and or approved by DEP. Some of those scopes of study, I'm sorry, so those investigation reports summarize that investigation work. That, because of the reasons I indicated, that couldn't be completed until more recently. And so regarding the plant building, these next steps that are identified as being part of the comprehensive report, those can't be submitted until the completion of investigation has happened.
And the investigation's not complete.
The company has completed its investigation. We've supplied the reports to DEP for review and concurrence. As far as I know, we haven't received definitive from DEP yet on, confirming that the investigation is complete and that DEP does not plan to request supplemental investigation, which, has happened in the past where we have submitted investigation reports that summarize results. And, it provides an opportunity for us to meet with DEP to review the documents, provide feedback, and that has resulted in putting together new scopes of study to go out and do supplemental investigation.
When you say the investigation is complete, you mean the portions of the investigation listed in those reports, or you mean all of the investigation?
I mean, the portions of investigations in those reports that are related to investigation of the plant building itself.
Several times in your testimony and in the written testimony at UI ERP 1 at page 34 and in other places, you reference unanticipated physical conditions at the site.
Would that be the question starting on page 32 of UI ERP 1? Did the company become aware of or otherwise encounter circumstances after the company accessed the site in 2016 that
Yes.
impacted the schedule?
Yes.
Yep, okay.
But those unanticipated physical conditions are not conditions that were discovered between the last rate case, that March 29th, 2023 date, and today.
My apologies. What was the question?
The unanticipated physical conditions described are not physical conditions that were discovered between the last rate case, the March 29th, 2023 date, and today.
I'm sorry, I'm still not hearing a question.
I can rephrase. Those unexpected physical conditions were discovered when UI first gained access to the property, not in the period since the last rate case.
I'm so sorry. Am I just missing a question mark?
If I can, I think it's an issue with the form. I've been holding back my objections on the form, but they do need to be stated in the form of a question as opposed to a statement.
Okay. Attorney Shane, can we just add correct and a question mark to the end of the sentence or otherwise rephrase, please, to make sure that they're in the form of a question?
I can, and the reason I've been a little hesitant to do so is that I've received quite open-ended responses beyond what I believe the scope of the question is, but I will make an effort to do so.
Okay, then thank you. Then I will sustain the objection and ask it to be rephrased as a question, please.
Is it correct that the unexpected conditions, physical conditions, were discovered when you first gained access to the site and not since the last rate case?
I would say that one of these conditions was the extent of contamination being far greater than anybody anticipated. As we continue to progress through the investigation, we do learn at times the extent, and that's oh, that's what we do in the investigation, is to define that extent. So to the extent that these conditions, these physical conditions, the releases that happened that we weren't aware of by previous occupants or users of that building after UI vacated, it's very possible that some of those conditions, were investigated.
And just to elaborate, so the section here on, in response to the question starting on page 32 of the testimony, it gives some specific examples of conditions that were not fully anticipated until after gaining access into the partial consent order, including the incomplete and insecure containment of asbestos that required additional abatement before the company could even get access to the building. So that's the presence of disturbed asbestos that we encountered, the tracking and spillage of oil in the plant building that was beyond what was anticipated. So these are some specific examples, but the reason I paused there was because, since the close of the evidentiary period in the last case, we've been working to advance the investigation of the plant building, including preparing these detailed summary reports that summarize all of the investigation work that's been performed in those areas of the building. And as part of that evaluation, there may have been determination, or based on the evaluation, that the extent of what was found in contamination from all that sampling exceeded what was assumed going into it, and required additional significant supplemental investigation. And so, when you ask about whether the conditions were identified from the previous rate case to present, I think there is some component there that, as we're preparing these investigation reports, we're learning about the impacts and the extent of impacts in a building. And, as happens with these investigation projects, they can grow. They can, you start your investigation, you collect some samples, you go back, prepare your reports, evaluate the data, and then you learn, and you collect additional or supplemental samples, and those conditions could be identified while you're in that reporting process.
UI first gained access for remediation in August of 2016, correct?
Yes, under the PCO, the company gained access to implement the PCO. It was around August of 2016 was the access date.
At page 41 of UI ERP1, there's a statement that it appears the department's position.
Would that be line 11 of page 41?
That's correct.
Okay.
So I can read the statement so I can follow the question. It appears that the department's position is that unless the company includes the demolition of the 100,000 square foot 10-story power plant building, well, that's the only part we need. The department's never formally taken that position.
Well, just to clarify on this point here, so the partial consent order doesn't require demolition.
Correct.
And it removed that requirement specifically, as I understand it, when the partial consent order was being negotiated, to remove that demolition component. In addition, it removed
That's the question is, has the department formally taken that position? And the first part of your answer was that it's not in the consent order, right? And then now we're into speculation about how the consent order came to be, and I don't think this is the form for that.
I'm gonna object to that statement. It's not a question to the witnesses. It's more a characterization. But I also do object to that question in terms of the witness's ability to espouse Deep's total interpretation. That's Deep's interpretation to take.
I'll withdraw the question.
Okay.
Do you know, under the consent order, who is required to prepare an evaluation of remedial alternatives?
That's UI.
And has UI prepared such a document?
We have evaluated alternatives and we have prepared documents that evaluate remedial alternatives.
But you haven't made the formal submission of that document as required by the consent order.
I disagree, respectfully disagree. We have prepared an evaluation of alternatives that was submitted to the department and it was even approved by the department. And that, was one of those partial steps that DEP agreed to so that the project could move forward.
I'm sorry, you're indicating that UI has prepared, and let's talk specifically about the power plant building itself.
Oh,
Has UI submitted an evaluation of remedial alternatives for the power plant building?
sorry, I guess I didn't understand the first question. No,
I was asking in the context of so let's ask that. Has UI prepared an evaluation of remedial alternatives for the power plant building?
going back to my previous response, we have prepared it. That's one of the partial components that DEP accepted and approved. It was submitted as a separate document specific to the areas outside of the power plant building. So we provided that and it was approved. Regarding the plant building itself, I go back to that line previously that the evaluation of alternatives, that step follows the completion of investigation. And for all the reasons that I've identified, and I know I've been lengthy in my responses, but the story is more complicated than than even we've responded to in our testimony here, that we've had to split up the project into these phases. There were all of these unknown conditions. And so that delayed us performing the investigation, but all along we were keeping DEP informed of the progress that was being made, including these report submittals, monthly reports, monthly progress meetings, et cetera. And it wasn't until more recently that we've submitted what, the company believes is the final investigation report that summarizes the investigation of a certain portion within the building for DEP's review.
So if the company has not submitted the evaluation of alternatives for the building, then the department has neither approved nor rejected any remedial alternative
For the plant building?
for the plant building.
That's correct, and also so evaluating the remedial alternatives, of course, that follows the investigation of the building. And the other piece, we mentioned it here, unless the company includes the demolition of the power plant building, the department's position was that the company need to evaluate a demolition scenario as part of the evaluation of remedial alternatives. And the company's position has been and is that demolition is not required. And so there's this ongoing dispute in addition to the cleanup standard, that as I understand it, the partial consent order, the stricter cleanup standard for the building was removed in its final version. And so what we have here is that DEP has requested the company to evaluate demolition and cleanup to a stricter standard than the company had anticipated going into this.
But that evaluation has not been submitted to the department. We're losing the thread here a little bit.
So, in order to be responsive to the department, to DEP, and to, again, try and keep the project moving forward, in spite of the ongoing dispute regarding the cleanup standard for the building, that demolition is not included. The company has prepared certain evaluation of remedial alternatives to be responsive to DEP and try and move things forward that have been provided, including there was a draft evaluation of alternatives that was provided for review around forget if it was the end of 2023 or early 2024. So some of that information has been prepared, and DEP and the company had continued to meet, to discuss the evaluation of alternatives.
But that document was not submitted as a formal submission under the consent order.
I don't know, I guess, what do you mean by a formal submission under the consent order? Because we have supplied certain evaluation of remedial alternatives documentation to the department.
A final evaluation of remedial alternatives for the power plant building for the department's review and approval under the language of the consent order.
Just same objection as earlier with respect to the interpretation of the PCO.
I'll withdraw the question. Would you agree that the document you were describing a moment ago was a draft document?
One of them, the one that I was referencing in late 2023, early 2024, additional documentation regarding evaluating remedial alternatives was provided to the department. And, does it have a draft watermark on it? I don't remember.
And you agree that the investigation of the power plant building itself is not complete?
I disagree. But again, it's more complicated than that because the company and its environmental consultants, subject matter experts from TRC, including the licensed environmental professional, they can make their opinion that the plant building has been adequately investigated, characterized, and then we take those investigation reports, provide them to the department, and then the department also has its opportunity, the department meaning DEP, to provide comment on those reports. So it's a little more complicated. Are you asking if I think the investigation is complete, or does DEP think the investigation is complete?
Has a completion of investigation report for the power plant building been submitted to the department? The entire building?
Looking back at the partial consent order, I don't see reference to a formal completion of investigation report. And again, the scopes of study for the investigation of the building with DEP's acceptance, those were divided into these smaller portions or partial areas of the building for the reasons that I've already explained. So the approach was to divide up the building, send in these individual reports for DEP's review and approval.
Has the department ever, to your knowledge, formally approved or rejected a remedial alternative for the power plant building?
I'd have to go back and check because work plans, including remedial plans, were provided for remediation work that has occurred in the plant building, the main plant building, including the interim abatement and remediation that occurred that allowed safe access so that we can perform our investigation of the building. So that was between the timeframe of 2017 into 2018. So I'd have to go back to that submittal to see if the department, formally issued an approval, but I can say that those work plans were discussed, reviewed with DEP. You know, we weren't just going out there and doing the work on our own without DEP's involvement. You know, they were involved. So that was the interim abatement and remediation in the building. But then also more recently, when I had previously discussed the boiler 13 interim remedial measure. I do know that that remedial alternative, that remedial plan to go out there, remove that source area contamination in the 2022 to 2023 timeframe so that we could continue our investigation. That was provided to DEP and reviewed. I can't recall off the top of my head if DEP approved, you know, formally issued an approval letter for that alternative, but the information was provided for an opportunity for comment and review.
For the interim remedial measure.
That's right.
I have no further questions.
Nothing further from anyone with the, all set? All right, thank you.
Thank you.
Let's move to cross by the authority staff, please. Attorney Riley?
Thank you, Chairman. Good morning to the panel.
Good morning.
I'm going to start with Bridgeport Avenue. So the total cost for HRP to conduct groundwater monitoring and developing a final verification report is approximately $81,000 subject to check. Is that correct?
Do you have the response handy? I may have located it. Would that be RSR 203?
I believe so.
So that was a proposal from HRP Associates, and it was provided as attachment, UI attachment 1 to RSR 071. That was the, you know, as described here in our response to 203, that was a more comprehensive proposal for the scope of work that included groundwater monitoring and also verification or closure reporting that's required on the project. So as noted here, that estimate, that proposal from HRP is greater than the rate year expense. I don't have the exact number you referenced, 81,000.
Okay.
It sounds right, but then the rate year expense was different.
Okay. Thank you. Understood. So I understand that to include groundwater monitoring and developing the final verification report, correct?
Yes.
So when is the final verification report expected to be submitted?
I don't have an exact date off the top of my head, but just to provide an update on the status, as I understand it, the groundwater monitoring has been ongoing. So we've continued to monitor the groundwater out there, and that's one of the steps that's required you have to demonstrate, you know, under the Connecticut regulations, compliance with the groundwater standard before moving on to that final verification step. So as I understand it, that is progressing, and the verification reporting, if it hasn't already started, is slated to begin this year.
Okay, so it's slated to start this year. Do you know when that final verification report would be submitted?
So as we've noted in ERP 1, page 14, line 10, we note that the final verification report to be prepared and submitted to DEEP in 2026 is the target.
Okay, and there's no update to a specific month for that time period?
Not that I'm aware of. I think it's still in that timeframe, but
Okay.
later this year, 2026, and some of that is dependent on the results from the groundwater monitoring. So it's hard to, provide an exact date.
Okay. And then once that final verification report is submitted, are there additional steps that need to be taken? Or could you just walk me through what happens after that verification report's submitted?
Sure. So the site is under or it's being overseen, investigation remediation is being overseen by a licensed environmental professional in Connecticut. So the step under the Transfer Act that this property is subject to is once the final verification is prepared, it's signed off by the licensed environmental professional, it's submitted to DEP, to the department. And then there's a certain period, and I don't remember the exact period, but there's an opportunity for DEP to audit that LEP or licensed environmental professionals verification report. But if it's not audited, they being the department, will typically send out a no audit letter. And then at that point, the project, as part of the Transfer Act, is done.
Okay, thank you. I'm going to turn to English Station next, specifically RSR 208.
I located it.
Okay, thank you. So this response noted that the company had discussions directly with New Haven city officials as recently as March 24th. What's the frequency of those meetings with the city officials? I think that's what the interrogatory response was getting at, or the interrogatory.
Yeah, so that was that specific reference to the March 2024 meeting. That was a larger meeting with the city of New Haven and others. And that type of meeting, I would consider on an as-needed basis, when the company feels that, or I guess, one of these other parties feels that a meeting is warranted. But, as described in the response here, the company, outside of the meetings, has also provided notifications when appropriate to New Haven Police Department on other occasions, to DEP and others.
Okay, thank you. So there's no standing meeting per se with city officials. It's on an as needed basis initiated by either the company or the city?
Specific to this question regarding security of English Station, or?
Yeah, I believe security related, yes. Discussions, are they?
Yeah, so as far as I know, for security related items specific to English Station, these types of meetings would be on an as needed basis.
Okay, understood. Thank you. Next, I think RSR 146 might be relevant.
Okay.
So the company is not seeking recovery for any expenses related to English Station and its proposed revenue requirement, correct?
Correct.
Okay. How does the company track time that employees charge to English Station?
Broadly, the company uses what we refer to as internal orders to track all nature of expenses related to English Station. And there was another data request response. want to say deep 6 or 7. That's just from my recollection. I haven't confirmed that that's right, where we provided an itemization of all of the costs that we've categorized as English station that are reflected on Schedule C 3.08, 3.08 that we have removed from the company's proposed revenue requirement via pro forma.
Okay, so just to make sure we're on the same page, so is that inclusive of labor that is charged by UI or any of its UIL, et cetera?
There were some responses in 220808. Again, off the top of my head, I want to say our supplemental response to RRU 367 and late file 60 that described, yeah, in that proceeding, not in this proceeding, that described the history of the treatment of those expenses with respect to the provision for environmental remediation on our books related to English Station, specifically for the period 2016 through, I want to say 2019, we had recorded both external legal and internal expenses associated with English Station to the provision on our books, i.e. the 30 million. Then in, again, subject to check, I want to say the 2020 timeframe, the company determined that said expenses were not eligible for the 30 million under the PCO and accordingly made a financial entry to remove them. And you can see that back and forth, I think also in the data request that I referenced. And if you give me one moment, I can confirm the reference for you. Yeah, I believe it is the attachment to Deep 6. Provides a complete itemization of what we've identified as English Station related for the last 5 years. Yeah, this is a Deep 6 UI attachment 1.
Okay, and does that include internal labor expenses?
It does.
It does, okay, so so any employees devoting time to English Station charged to a certain code, and that code captures the hours and et cetera, the labor expense, and then removes from the revenue requirement?
My apologies, I can't answer your question, but could you please just re-ask it?
Sure. So I'm trying to understand how the labor expenses flow into Deep 006 attachment 1, essentially. So in other words, how does the company keep track of time devoted to English Station and then ensures that it's removed from the revenue requirement?
And you can see the history that I just described reflected in this attachment to some extent in the years 2019. And I have Deep 6 UI attachment 1 up and I'm looking at it now. You can see in the 2019 and 2020 columns, there are a lot of rows related to payroll and overhead with some numbers in them. As in those years, the company was charging these costs to the PCO. However, following the determination that said costs were outside the scope of the PCO, my understanding is the company stop tracking the discrete hours of its internal employees based on the position that those hours do not constitute environmental remediation activities associated with English Station.
Okay, so that's for the purpose of the company keeping track of its $30 million PCO commitment, is that correct?
In effect, that's right. I think technically the liability on our books, and I'm going to say this subject to check because I'm not 100% certain. I think it is for the anticipated cost of environmental remediation at English Station, not precisely the 30 million. And I know that sounds like a distinction without a difference, but I'm just anticipating the number on our books is not going to be exactly 30 million.
Okay, so I want to make sure I understand this correctly. So from the time period 2019 through 2021, the company was keeping track of labor expenses and then essentially taking those expenses and counting them towards the PCO cap. It later determined that the PCO cap did not include internal labor expenses, so it stopped keeping track of those at that time.
I think the gist of what you've got, I think is consistent with my understanding. I think the timing, I understand a little differently, although I don't know that that's the germane part of your question. My understanding is up until 2020, this was what was happening. And this attachment only goes back to 2019, but I understand that was the practice before then as well.
Okay, so through, let's say the end of this determination that UI made regarding the applicability of that time to the PCO, it stopped keeping track of that time altogether?
My understanding is the employees stopped recording time to orders that landed in that bucket that we're counting as PCO.
Okay, so those employees that work on those employees that work on English Station charge towards distribution that are included in base distribution rates. Is that correct?
I think the technical term would be they charge their default payroll order because they're doing regular work for the company or one of its affiliates, not specifically environmental remediation work that's eligible under the PCO.
Okay, so at present, there's no accounting for staff time at English Station.
One moment. And I'll give you a yes or no answer if you could please just repeat so I can say the right one.
Sure. So presently, there's no accounting for staff time devoted to English Station.
That is my understanding.
Okay, thank you. So any of that time that is charged to UI distribution and spent on English Station is being sought for recovery then?
Although, again, I'd just clarify that none of that is eligible for the PCO. So there's no dollar that we're counting against the PCO that we're seeking to recover from ratepayers. That 30 million is entirely from us trying to recover some portion of that from ratepayers.
Yeah, I think maybe we're misunderstanding each other is how the PCO and base distribution rates are interacting. So I understand your testimony to be that there is no timekeeping practice at currently. So that's correct?
That is my understanding.
Okay.
That's right.
Thank you. No further questions, Chair. Thank you.
Do you mind if we take just one moment to see if we have further comments in response to your last question?
Sure. Thank you.
We're good. Thank you for the patience.
Thank you.
Thank you.
Thank you. Let's move to across by the OCC, please.
Good morning, Tom Wheel for the Office of Consumer Counsel. We're going to start with some questions from Pradisha Bandari, Attorney Bandari.
Good morning.
Morning.
So I'd like to start with some questions about Bridgeport Avenue, and I think the Pura staff may have asked some similar questions, so I apologize if this is a bit repetitive. Looking at page 14, line 17 of your testimony, you say that the expected rate year cost for sampling and a verification report are $56,000, correct?
That's correct.
And the rate year is November 1st, 2025 through October 31st, 2026, correct?
That is my understanding, correct?
So how does this 56K estimate compare to the estimate provided in the company's last rate case, 220808?
Could you be a little, I'm not sure I understand, compared to the last rate case?
Or asked another way, do you have an estimate from the previous rate case that we could pull up and take a look at?
Sure. So in that case, you provided an estimate based on the multi-year rate plan that was proposed there. It looks like that number. All right, give me 1 second. So I'm just trying to understand how that works with this proposed rate year. That number in that last year that you estimated.
What, sorry, is there a specific reference, Attorney Bandari, so we can just pull it up or just try to track along?
Sure. Hi, Tom Wheel again. In the last rate case, 220808, exhibit UIRRP 1, good goodness, page 43 had a table, like a timeline table for this project. So I think the nature of Attorney Bandari's questions are just sort of how to align. That table was structured with the expectation of the multi-year rate plan that was going to start subsequent to that rate case. And now we're kind of shifted forward in time in a way that makes it difficult to tell kind of how the number we're seeing in this testimony compares to what was proposed in that last case.
Yeah, thank you. I do recall that table. Vaguely.
Just a moment, please. Okay, I think we've located the reference table. Yeah, so reviewing that table, it looks like between the time period of approximately Q1 of 2023 through the middle of 2026, we were anticipating being in the groundwater monitoring phase. Sorry. And then around Q2, Q3 of 2026, entering the final verification reporting. So
fast forward to today, the schedule has fluctuated a little bit. The costs are still similar, I would say within range for a scale of the scale that this project is. But based on my understanding, it seems that the groundwater monitoring has progressed a little more rapidly than we had anticipated when this schedule was provided. So that could account for some of the variance in the dollars between this projection and what is in the current case for the rate year.
And just so I'm clear, the proposal for Bridgeport Ave is just to include it in base rates. There's no deferral request like with East Shore.
That's correct.
Thank you. Now, based on your testimony in response to Pura staff, it sounds like the annual cost could potentially change after Deep's review of the final verification report. Did I understand that correctly?
I mean, potentially, as I indicated, the process would be we submit our final verification report that's signed off by our licensed environmental professional. And that, up through that scope, as I understand it, is included in that HRP proposal that was provided as an attachment to one of the responses, and I can look it up. If DEP were to audit that verification or request something else after the verification was submitted, I don't believe that would be included in the proposal or the contract that we've provided here.
Thank you for that. But after final verification report, is the remediation complete?
Subject to, unless DEP, like I mentioned, makes the decision to audit the verification. But yes, when the licensed environmental professional puts their stamp, signs off on the verification report, that's the final stage of the investigation remediation process for Transfer Act sites.
Okay. Thank you. Is there a transfer of establishment form that's filed with DEEP about this site?
Sorry, could you ask it a little differently? Like currently, or have these transfers occurred in the past?
Currently.
Sorry, I guess I don't understand the question. There have been transfers, the property was identified as an establishment pursuant to the Transfer Act. There have been transfers previously, and transfer forms were filed with DEP for those transfers, if that's what you were referring to.
Okay, and are these in the record?
Just one moment. I don't know, for this proceeding, but also I can't recall if it was provided in previous proceedings.
Okay, could we get a late file on that, please?
It will be late file exhibit 70. And Attorney Boundary, if you could just restate for the record, please.
Sure. So we are looking for the most recent transfer of establishment forms and also the environmental condition assessment form.
For the most recent transfer?
Yes.
I apologize. The environmental assessment form, is that the second half?
Environmental condition assessment form, excuse me.
Thank you.
Thank you. A couple more questions about Bridgeport. Looking at your testimony, page 15, lines 1 through 6, you talk about how the timing of SIR activities is subject to variability due to various factors. And you mentioned negotiations with third parties for property access as a factor. Could you please provide some more details about how these negotiations generally work?
So is this, sorry for the delay, I just want to look back, specific to Bridgeport Avenue or
Yes.
globally? I'm going to ask my colleague, Mr. Burgess, on the specifics for there. I believe we have an access agreement, but subject to maybe what he knows.
Yeah, as I'm aware, there's a access agreement in place that allows the company to get onto the property to perform its work, including the groundwater monitoring activities that were referenced.
Okay, I just want to make sure that I'm clear about this because on page 15 of your testimony, you do mention that access is an issue specifically for the Bridgeport Avenue project. So just so I'm clear, there is some sort of access agreement that was made with the current owner of the property?
I think maybe a little clarification on that. That Q&A was not meant to be specific to Bridgeport Avenue. It was just more globally of what happens in our program from time to time. So it's more global to what happens with SIR projects holistically.
Okay, so in that case, in general, when it comes to SIR activities, could you talk a little bit about the negotiations that you typically face when trying to access these properties?
They're, sure, I'll do my best here. They're, site specific. We're looking to get on to collect our data necessary to investigate and remediate. Depending on the owner, their activity on the site, we might have to work around those conditions. And so I think it's, what we strive to do is be able to get off do our work with minimal impact to property owners as a general rule.
Okay, and who typically performs these negotiations?
So that would be a team. We have what we call the real estate and property group that will work on those. And if we need legal support, we have that.
Okay, and is the cost of that legal support included in your requested recovery?
For Bridgeport Avenue, we don't have legal costs in there since access, to the best of our knowledge, is already there. It could have been part of the sale and purchase agreement.
Okay, and what about English Station? I know that you are struggling to get access in that scenario as well.
Right, correct there. We have access as part of the execution of the consent order.
But, just to add to that regarding English Station, there, as I've identified previously, there have been issues and delayed access to get onto certain areas of the property or to get the current owners or the previous owners sign off that was required by DEP and or EPA to move certain scopes forward. And if there's, you're asking about legal costs associated with that. And I think that refers back to Mr. Hurwitz's, response in that if there were outside attorney charges for negotiating access, those are tracked separately and not counted towards the partial consent order.
And just for what it's worth, I can offer that RRU 222 supplemental UI attachment 1 itemizes all of UI's legal expenses in the historical test year, including those related to English Station, and shows exactly what we removed for that reason.
Thank you, I appreciate that. It's very helpful. Moving on your testimony, page 13, lines 16 through 22, you mention alternative groundwater analysis approach for petroleum hydrocarbons that reduces the duration of groundwater monitoring. Can you explain how this approach differs from the initial approach used?
So the initial approach was to perform groundwater monitoring and compare to the default criteria that DEP has in place under the remediation regulations. And as I understand, this variation here was to evaluate an alternative approach of requesting alternative criteria from DEP, which is allowed under the regulations, and there's a process for requesting those alternative approvals, and that allows the company to advance the schedule a little more, in an expedited fashion here.
Understood. Looking at English Station, could the panel please turn to the response to Deep 13? So looking at the table on page 2, I see that in February 2024, the company added warning signage to the locked swing gate on the recently added interior exclusion zone fencing across the site. Now, when was this interior exclusion zone fencing added?
I believe it was covered in a separate response. So if you give me a moment, I will pull it up and try and locate that.
No problem.
Yeah, I don't see that specific activity called out in one of the responses, or at least a specific date for that activity. But from my recollection, that exclusion fencing additional measure was added sometime, subject to check, December 23, January 2024, around that time period.
Okay. And would you be able to tell me if there was any signage that was present on that swing gate prior to February 2024?
So I did find reference to that. If I could just back up, it is, which one am I at? Deep 13.
Mhm.
Installed, the second page of that, January 2024, installed interior exclusion zone fencing across the site from east to west. Further, February 2024, added warning signs, including to that exclusion zone fence.
Thank you. My question was there any signage present before February 2024 at that spot?
And because the interior exclusion zone fence was an added measure that was installed in the January, yeah, it was a new fence, so signage wouldn't be on it because it was newly installed at that point. Of course, there was additional signage that was in place at the site, but that specific reference to that exclusion zone fence, that was a new fence, so the signage would have been installed after the fence was put there.
Okay, so if I'm understanding you correctly, there was about a month between the installation of that fence and the signage being put up based off of the dates that you just provided. Would that be right?
Just based off of the rough general timelines that I'm seeing here, potentially it could have been, because we're providing months and not specific dates, it could have been very close together. But also, just to provide some context, this is an interior fence.
Mhm.
So it's approximately halfway across the property itself, there was already in place warning signage on the exterior portions of the fence, and I believe also on the building itself.
Okay, thank you. That kind of leads into my next question. I see that in February 2024, you also added a danger, do not enter bilingual sign to that interior exclusionary zone fencing across the site. What was the case there? Was it the same thing where there was about a month between the fence going up and that sign going up, or was there a sign there already?
And this is still in response to DEP 13.
Yes.
February 2024, added danger, do not enter bilingual signage on the recently added interior exclusion zone fence.
Yes.
I think that would be a similar response to the previous one. We called this out as separate signage, but as I understand it, the fence and then the gate that's referenced in the line that's higher up there, February 2024, that's on the same run of fence. So it makes sense that it would have been installed at the same time period.
Okay, thank you. And just curious, why did you decide to put a bilingual sign on the fencing but not on the swing gate?
I mean, looking at the warning signage, reference here that we have on the lock swing gate, I don't know that we didn't include bilingual signage. It could have been, we didn't add that detail here. But also, thinking about the exclusion fence, the signage is, it's at certain intervals across the fence in visible areas. So for reasons out in the field, it could have been made that there's, the signage makes sense where it is, and there's enough signage here that we don't need to add additional signage. It could end up where it's right on top of each other.
Okay, thank you. That was my last question. I'm going to hand it over now to Attorney Wheel.
Thank you. Chairman, I am looking at the time. I think I might have a little bit more than half an hour of questions. So I'm not sure if you wanted to, if I should go through until lunch, or I of course defer it to you.
Thank you. I think let's keep going until 12:30, please.
Okay. I'm going to start with a follow-up question from Attorney Bandari's questions about the Bridgeport Avenue cost from last year. I guess what's standing out to me, or what I was a little confused about, is that my understanding of the proposal from last year was that the final verification reporting was going to cost about $51,000, but that cost is going to be incurred across into 2027. So, and the total rate year proposal for this project is now $56,000. So I guess a simple way of asking it is the final verification report, how much, is that going to be completed within this upcoming rate year?
Just Attorney Will, while the witnesses pull up the materials, when you say last year, are you referring to the initial filing from 2024, or are you referring to the 220808 case? Because I know that Attorney Bandari had some questions about that.
Yeah, sorry, I was referring to the 220808 proposal.
Would you mind repeating the question again?
Yeah, maybe I can ask it more simply. My understanding from the 2208 proposal was that the final verification report was going to cost $50,648, so around $51,000.
It may tie back to my previous response where the when that schedule was prepared, it was based on a certain assumption with a schedule and an associated cost. Since then, we've completed some substantial groundwater monitoring activities and are now rolling into the verification stage. That may have shifted the schedule and cost where we don't have a full overlap with the rate year.
Understood. So is the total rate year ask for this project now fully in the final verification reporting and there is no more groundwater monitoring?
I'd have to check. I don't know if, getting back to the question about groundwater monitoring, I don't know if there's additional physical sampling that's required, or if at this point it's now review and interpretation and evaluation of those groundwater results and then incorporating them into the verification report. And so that part of that is still groundwater monitoring related, but it may not be the physical sample collection.
Okay. Thanks. I'm going to turn to some questions about East Shore. I think actually most of my questions are about East Shore. Your testimony on page 6 discusses manufactured gas plants or MGPs. It's my understanding that the contamination at such plants, including East Shore, comes from feedstock materials like coal and petroleum that were used in the manufacture of manufactured gas. Is that correct?
In general, contamination on, certain contamination could result from those types of processes when we're talking about manufactured gas plant. But, that was part of the history of East Shore. There's also, other historical uses at East Shore.
So, well, what caused the contamination that needs to be remediated now?
It could be a variety of historical uses and operations. I mean, this is a parcel in New Haven that has a long industrial history going back to approximately 1930-ish. There was, and it's along the shoreline, so there were historic filling operations of this, coking plant that are referenced here. The company also constructed a electric generating plant on the property, and it was used for electric generation, substations on the larger East Shore property, laydown yards, operations center, and other, potentially other uses that could have contributed to contamination.
Okay. And the current use of the property, like it says on page 9 of the testimony, is to store equipment and materials, and it says contractor laydown. Is that like temporary staging?
Do you have a line reference on page 9?
Sure. Line 15.
So the East Shore, the larger East Shore property, addressed at 1 Waterfront Street in New Haven, that has multiple different uses. I referenced the electrical substation, the distribution contractor, laydown area. There's a storage building out there. There's equipment that's stored on site. There are various, other uses on that larger property.
There's an active substation on the site?
On the larger East Shore property, the 1 Waterfront Street, but we make that distinction in the testimony here that the scope of the remediation is limited to a portion of that property.
Okay. So the portion of the property that it's limited to is currently just used for storage and contractor laydown?
As far as I know, I'm not aware if there are other uses, but there's, contractor and, company use, like the storage of the company's electrical equipment, for instance, on the remediation project site.
Okay. Thanks. And I see on Schedule C 3.21 working paper that the proposed amortization expense is 482,000. Is that correct?
It sounds right, but I'm pulling it up.
Okay.
I do see that amount reflected here, and you may be about to establish this, but just for clarity, the 482,000 reflected on Schedule WPC 3.21 relates to costs that UI has already incurred. The amounts that I think we were discussing before, I can't remember if we actually cited a dollar figure, but we have a separate request related to forward-looking amounts.
Understood. I am about to ask Brent to look at a completely different exhibit. So are you satisfied? Did you still need to look at Schedule C, or are you?
I located it. It's on line, and you're referring to line 15?
Yes.
Okay, I see that. Sorry.
Okay. I just wanted to see if that ties back to UI RRP 22. Do I have that right? Hold on one moment. Yeah, UI RRP 22B.
It does.
Okay, so that line 6 on that very first page, that's the derivation of the 482 that's in the C schedule?
That's exactly right. And the subsidiary pages of UI RRP 22B provide further insight into the derivation of that amount.
Okay. And the derivation is the costs of 430,000 incurred through July 31st, plus the carrying costs recorded to the same date, and that gets to 448,000. Is that correct?
Correct, with an additional $34,000 of carrying charges attributable to the period August 2024 through October 2025, taking you to the 482,000 on the schedule you identified a moment ago.
Okay. So the notion there that it's sort of it's the total deferred cost, the carrying costs up to July, and then adding the carrying costs to get through the end of the interim period?
That's exactly right. And we submitted some direct testimony in the revenue requirements panel on this, but at that point, we'd propose reflecting this $482,000 balance as an element of rate base, and we've reflected the rate year average in our proposed level of rate base in the revenue requirement.
Okay. Is the company continuing to incur costs? Like, were the costs incurred subsequent to July 31st to remediate this project?
July 31st of 2024?
Yes.
Yeah, the company has continued to perform its investigation and remedial planning work.
Okay. I was just curious if this is the 430,000 is going to be subject to like a update in late file 1, or if the deferral is going to stop on July 31st.
We do not intend to update this particular deferral in LFE1, rather, and you can see this goes back to a period of time that predates the historical test year. This exhibit, page 2, goes back to August 2022 because we used a similar practice in the last case, docket number 220808. In that proceeding, we saw costs through a certain historical point in time, subject to check, I will say July 2022. We, because that was the latest information available that we were able to marshal at the time of our initial filing in that case. And now we're seeking the costs that were incurred after that date in this proceeding. Same concept in the next case. To the extent the company continued incurring costs after July 2024, I'd anticipate the company seeking to recover those in a future proceeding, but we do not intend to update LFE1 here.
Okay. Thank you. On page 2 of the same exhibit, RRP 22B, Mr. Hurwitz, you just referenced that the kind of start point of this deferral is August 31st, 2022. And I heard you say that that was consistent with the last case. I was just curious about about why specifically that was the start date for this deferral.
This deferral, like I think subject to check all of the other deferrals in our initial filing, we endeavored to reflect the most current information possible at the time we were preparing the revenue requirement before we initially filed. Obviously, our initial filing in this case happened after July 2024, but can't just snap your fingers and get revenue requirement. It takes time for the books to close, to finalize the calculations, to prepare the revenue requirement. There's a 30-day substantive notice requirement here in Connecticut, although I'm not a lawyer. So this is the most current information that we were able to reflect in our initial filing based on the time that we filed the case.
But why did it start in August of 2022?
Oh, my apologies. Because we followed that same methodology in the last case. So any amounts the company incurred through July 2022, we would have sought in the last proceeding.
Okay.
And our path to cost recovery is that request. Obviously, we are unsatisfied with how that was resolved, but it is what it is, and we're
Okay.
litigating that separately.
So yeah, I was going to ask, not to get into the litigation or anything, but it's my recollection that the company sought recovery of deferred expenses for this site in 220808, and that was denied. So is that correct?
That's my understanding.
Okay. And so the August 31st, 2022 date is sort of like the start date, is the next date following where the last request ended? Is that what you're saying?
That's right. We're
Okay.
not trying to double request the dollars that were requested last case.
Okay. Thank you. Moving on to exhibit ERP 5.
And just to note, are we looking at the redacted version or the confidential version? of these?
Redacted.
Thank you.
And so these are the expenses. This is the support for the deferred expenses for this site. Is that correct?
That's correct.
Okay. Why do these invoices start in February instead of August of 2022?
Just for clarification, are you referring to the ones in the third column that says invoice SAP posting date 3/23/22 with a number 3 footnote?
Just a second. Well, yeah, I was looking at either the invoice date or the invoice SAP posting date. I noticed that there are a number of 6 or 7 invoices that look like they predate August of 2022. I'm looking at page 1, by the way, of that exhibit.
Attorney Wheel, I see why you asked this question, but I think whoever prepared this exhibit may have seen that too, because they left a little footnote, I'm seeing a little tiny 3 right next to the, for example, March 23rd, 2022 invoice, the first invoice. And it took me a minute to put my eyes on it, but in the middle of page 2-ish of this attachment, right below the table, you can see a collection of footnotes. And footnote 3 explains that invoice was initially posted to an incorrect order inadvertently. The company subsequently reclassified the invoice to the correct order on January 31st, 2024. And just knowing some things about how regulatory deferrals are captured and recorded at the company, the order to which costs are recorded is an important thing for picking them up in the deferral. So my educated guess is based on the order to which this cost was posted originally. It was not captured in the deferral previously, but was captured in the deferral as of the date of reclassification noted here.
Okay, so does that sort of align conceptually with what we talked about a minute ago, that these were costs that weren't included in the 220808 request for this site?
That is exactly right.
Okay. Thank you. There are, looking back again at RRP 22B, there's a list of invoices on that exhibit as well. I noticed I wasn't able to match the invoices between these two exhibits exactly. Like it looked like things were kind of, I could give an example, but it looks like things are kind of in the range, but not ever exactly on target. Do you know why that might be?
I have one extremely educated guess, and maybe if you have an example, we could see if my guess is gonna be the explanation.
Sure. The easiest example I could find was the very last item on page 3 of RRP 228. So that shows it was posted 7/26/24 for $2,270.28. And if I compare that to the very last item on ERP 5, same posting date, but it's $2,228.39.
Yep, just one moment. Yeah, I got it. So what I did is I have the Excel 22B up, and then I just typed in the number from the other document that you cited, the $2,228.39. And then I escalated it by 1.88%. It's a very specific percentage. This relates to sales and use tax, which is not always reflected on the invoices sent to the company, but the company does have a subject to check. It is called a managed compliance agreement with whatever the Connecticut taxation governing body is called. Their name escapes me, my apologies, but we have a managed compliance agreement where costs recorded to certain GL accounts attract 1.88% sales and use tax, and that's clearly what this difference is.
Would that be our friends and neighbors at the Department of Revenue Services? Is that the?
If you said that with enough confidence, I would believe you.
Thank you.
I don't recall the exact name.
Okay. Thank you. So that's, so 20, I'm sure I could figure this out myself, but 22B is the one that's grossed up for that tax effect?
That's right. The
Okay.
environmental exhibit UIERP 5 should be copies of the invoices as they were sent to us. And then 22B should be copies of our invoices as they were recorded in the accounting system. And to the extent those numbers differ, my expectation would be this 1.88% is the reason why.
Okay. Are these two exhibits primarily ERP 5, but also RRP 22B, the full set of documentation for these costs? Like, is there any other exhibit or interrogatory response that documents the cost supporting the deferral?
Use the word full, which is a very broad word, so I'm just hesitant to agree on that basis alone. But this exhibit UI ERP 5 does present the invoices underlying these costs, and 22B demonstrates how we've translated those invoices into the costs that we're seeking to recover in this case. We've also submitted direct testimony from my colleagues on the environmental remediation panel to describe, the company's approach to these projects, the nature of these expenses. I think we've answered some other data requests adjacent to this, so we provided copies of the invoices underlying our request, explained why we've incurred these amounts and why we think they're eligible for deferral. We've answered data requests about the nature of the costs and why we want to do the work that we're proposing in this case. So the use of the word full scares me a little bit, but this is the support that we offered in our direct filing. I would agree.
Okay. Thank you. I have some questions about the recovery proposal. And we're going to work together and see if we can get through this in 4 minutes. On page 11 of the testimony, it discusses how there's a total anticipated, I think, $10.5 million cost, with 7.5 of that expected to be incurred in the rate year. Am I understanding that correctly? Incurred, not recovered. I mean, we're gonna get to the recovery next, but
That's correct.
okay. I noticed in response to OCC 705, my understanding from that response is that the derivation of that $10.5 million estimate is from a projection that was completed in May 2024. Is that correct?
That's right. That number is derived from this May 2024 engineer's estimate that was prepared by the company that is the licensed environmental professional in the engineering firm that's overseeing and part of the project.
Okay. And can you please open the attachment to that? It's OCC 705, attachment 1. I'm specifically looking at page 3 of that attachment.
Okay.
So there's a red box on this page that I take it to represent the rate year portion of this estimate. Is that correct?
Yeah, that's right. That box calls out the projection or the estimate within that rate year period.
Okay. And I added up the totals, the 4 totals at the bottom line there, and got 7.488 million. And my assumption was that was the 7.5 that was referenced in the testimony. Is that correct? The amount to be incurred in the rate year?
Yeah, that's correct.
Okay. And the year following the rate year, like if I added up the following 4 quarters, I got 3.28%. So is the cost expected to go down like 50% the year after the rate year? Not percent, 3.28 million.
Without doing the actual math, I see the decrease, but that, looking at the third row up, we're entering into the remedial action phase, which is the largest spend on these remediation projects. It typically happens during the remedial action phase. And so, a lot of that is scheduled to happen in the rate year. And then I see that spillover into the next quarter.
Yep. Okay. Yep. I see that. And then for the following 3 quarters, there's no remedial action phase anymore, which is why it dips from 3.125 million in Q1 of the next pretend rate year all back down to 33,000. Is that right?
Right. Or if there is remedial action, it would be at a much lesser extent than the full, site remediation, the initial mobilization.
Okay. What's the significance of the multicolored, primarily green column that's dated January 1st, 2024 through June 30th, 2028? I just wasn't able to kind of understand why that column got colored. It's to the right of the red box.
I see it and I can't, I guess, speak specifically to why the engineers of the LEP put it together this way, but it looks like there was an attempt to kind of show a subtotal for a period of time. And that's what that column may represent. And then the site-wide or project-wide total would be further to the right in the table.
Yeah, thanks. That much I understood. I just wasn't sure if like, is there a major milestone at that point at like June 2028 where does that represent like a significant piece of the project that'll be expected to be over or something?
I may have had a similar question, but then I looked at the bottom of page 2, for example, and I see there's a little legend describing what the intention of the various highlightings.
Ah, thank you. I can look at those on my free time when we're not waiting for lunch. So thank you. I'll retract that question. And the proposal is to recover the expected 7.5 million, approximately half in base rates, 3.7 million in base rates, and to defer the difference, whether higher or lower, as an asset or a liability. Is that correct?
That's our proposal. That's correct.
Okay. How'd you get to 3.7 million for the base rate amount?
It was half the rate year estimate.
Okay. And the testimony noted that that was similar to what was allowed for SCG in 23-1102. Correct.
We may have stated that. I don't recall that. I take that subject to check though.
Okay. Subject to check, do you recall that the expected cost discussed in that case was a total of 1.3 million and the proposal was to put 893,000 in base rates?
I don't recall offhand, but I can check very quickly if you'll bear with me. This would have been LFE 211 attachment 2 as I think this would have been an SCG request in our case update. I have a little over 1.4 million as our request across the 3 different sites in question for that company.
Okay. I guess my question was, my understanding, which I guess I'll ask you to correct if I'm wrong, in that case was that it wasn't exactly half that was proposed to be put in base rates. And if that is correct, I was just curious, like, how the decision was made there, if it wasn't just splitting the baby as opposed to here where you just said it was half.
And I think each decision was made based on the specific facts and circumstances of each case. In the recent SCG rate case, one significant distinguishing fact is the level of test year expenses associated with their environmental sites. I just noted that we were seeking approximately 1.4 million across 3 sites in that case. The test year level of expense for those 3 sites was 1.3 million. So subject to check, my recollection is we just took the test year plus the inflation factor applicable to that case. In this proceeding, we have an engineering calculation supporting a quite significant increase in costs into the future relative to what we saw in the historical test year, a difference in the fact pattern relative to that case. And so accordingly, we arrived at a different proposal.
Okay, thank you. That was OCC's last question for this panel.
Thank you. NECTA, the Attorney General. No questions? Thank you. EOE. Thank you. Commissioner Karen. I also do not have any questions. So attorneys, I will give you the option. We can either take a 5-minute recess for you to consider redirect so you can let your panel go, or we can take our lunch break and do redirect when we come back.
Thank you. And we probably do need a few minutes to discuss. I'll defer to you in terms of whether you think it's best to take 5 minutes now and then ask some limited questions or wait until after lunch. Either way works for us.
Okay, then let's just go ahead and take our lunch break, and we will reconvene at math, 1:20. 1:20. Sorry. Good afternoon. Welcome back to docket number 24-1004. Attorney Vaughn or Attorney Hum?
Thank you. We have no redirect.
Thank you. All right, this panel is excused. Thank you. All right, I'll ask authority staff to approach the cross-examination table and the company's rates and rate design panel to witnesses to approach, please.
And Chair Gillette, while we have the panel move forward, at some point this afternoon, would it make sense to kind of recaucus the parties on cross? I feel like there were quite a few shifts on this panel as far as cross-examination goes, and I just want to make sure that I'm kind of tracking the right schedule for our witness panels and everything.
Very
like that.
good. We can definitely do that before we adjourn this afternoon. Yeah.
Thank you very much. Sorry. While everyone gets settled, we do have a bit of a larger panel for this. So we do have Mr. Patel in the back who'll come up for the swearing in and adopt his materials, and
Okay.
we can shift him up as appropriate. Are you good? Thank you. I think we're all set.
Okay. All right, Attorney Vaughn, if you want to introduce your witness panel, please.
Sure. To the panel, would each of you please state your full names and positions for the record, beginning with Mr. Patel and then Mr. Colton.
Michael Pertel, Director of Advanced Load Forecasting and Analysis.
Mark Kolka, Manager of Pricing at UI.
Kumar Chaladanki, Director of Center of Excellence, Business Transformation Customer Service Systems.
Benjamin Lobick, Manager, Smart Meter Systems Operations, Connecticut.
Heather Tabbets, Director of Regulatory for United Illuminating.
Vicky Rimal, Vice President at Concentric Energy Advisors.
Thank you. I believe none of the panel members have been sworn in as of yet.
Very good. If all the panel members could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
I do.
Thank you.
Mr. Patel, I'll begin with you. Mr. Patel, as part of your preparation for this docket, did you provide pre-filed direct testimony and exhibits which were marked as exhibits UI MJP 1 through 3?
Yes.
Did you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Do you have any updates or corrections to your pre-filed testimony or interrogatory responses not previously identified for the record in an interrogatory response?
No, I do not.
And do you adopt your pre-filed testimony and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Thank you. Mr. Kolka, Mr. Lobick, Mr. Jaladanki, Mr. Tharian, and Mr. Ramal, as part of your preparation for this docket, did you provide pre-filed direct testimony and exhibits which were marked as exhibits UI RP 1 through 12?
Yes.
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 And Ms. Tebbets, along with Mr. Kolka, Mr. Lobick, Mr. Jaladanki, Mr. Tharian, and Mr. Ramal, did you all co-sponsor pre-filed rebuttal testimony marked as exhibit UI RP Rebuttal 1?
Yes.
Yes. Yes. Yes.
And to the panel, did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
No.
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 Thank you. Mr. Ramal, as part of your preparation for this docket, did you also provide pre-filed direct testimony and exhibits which were marked as exhibits UI-BR 1 through 5?
Yes.
Do you have any updates or corrections to your pre-filed testimony or interrogatory responses not previously identified for the record in an interrogatory response?
No, I do not.
And do you adopt your pre-filed testimony and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
To the panel, sorry, same question to the panel.
Yes.
Yes.
Thank you. Ms. Tebbets, for the purposes of admission into the record, have you reviewed and do you adopt the interrogatory responses sponsored by Mark O. Marini?
Yes.
Thank you. And for the panel, last question, for the purposes of admission into the record, have you reviewed and do you adopt the interrogatory responses submitted by other individuals identified in the company's April 24th, 2025 letter on witness panels in the area of rates and rate design?
Yes.
Yes.
Thank you. The panel is now available for cross-examination.
Thank you. Very good. We'll turn first to authority staff. Attorney Tanaka, please.
Thank you. Good afternoon. I'd like to start out with attachment 1 to UI's response to RRU 1. If you could maybe pull that up. It includes a statement on page 4 specifically that UI's ACOS methodology is generally the same as UI's last rate case. That's docket number 220808, but identified 3 changes. So if you could just find that section, combining rates R and RT into one class, minimum system study based on embedded cost, and FERC account 362 station equipment allocated using class contribution to system peak. So if you could just find that section, although I don't know that you'll need to find it to answer my next question.
Was the reference to RRU 1? Sorry, I missed it.
RRU 1, attachment 1, I believe it's on page 4. Again, you may not need to be there, but.
Yeah, I'm there.
And could you identify how each of those changes that are identified there impacted the cost study in terms of classification, functionalization, and allocation of costs?
Can you elaborate? What do you mean, how it impacted in terms of results, or I don't understand?
So those 3 changes, right, the combining rates R and RT into one class, right, those 3 listed changes, how they impacted the cost study in terms of classification, functionalization, and allocation of costs. You need further clarification on those impacts?
So when you say impacts, do you mean if we hadn't made those changes, or that's what I'm struggling to understand?
Sure, how those changes, what the results of those changes, what the impact of those changes was. the results of those changes?
I don't believe we've done a counterfactual study to actually quantify the impacts.
Okay. Could you give us at least a high-level understanding of the impact of those changes on the cost allocation at a customer class level?
It's difficult to say without actually doing the study because the three changes could be impacting results in different directions. So it's not just looking without running the study itself. It's hard for me to quantify what the impact would have been.
Okay, so based on, I assume you have an understanding of the report in 220808. So can you not make any comparison between the results in that study and in this study based on these changes?
I cannot comment without actually running the study to quantify the impacts. But I can at least, sorry, I'm just going to add one thing. In general terms for classification, functionalization, classification, and allocation, we haven't changed functionalization and classification, but allocation could have changed because as you can see on the third change where we were changing the allocator to 1 CP, that would change the allocation results.
Could you provide the percentages allocated to rates R and RT for FERC account 362 station equipment?
You asked for the percentage allocated to R and RT.
Correct.
Okay. 52.56%.
Thank you. Can you explain a little bit how FERC account 362 was treated differently in this study than in the study presented in the last rate case in 220808?
Yes. So in the last study, 220808, FERC account 362 substation station equipment, as it's referred to, was allocated using non-coincident peak of individual classes. And in this study, we're allocating those costs using single coincident peak. So based on the contribution to system peak from individual rate classes.
And now I'm going to refer to Exhibit UI RP Rebuttal 1, the rates panel rebuttal testimony, and starting on page 11, line 17, just going on a couple of lines onto the next page. There's a reference there to customers benefiting equally from the minimum system. So just hoping you could explain how all customers benefit equally from the minimum system. Again, that's UIRP Rebuttal 1, starting on page 11, line 17, and I think it ends on page 12, line 2.
So what we're trying to say there is the minimum system or minimum system would be able to, that's just based on minimum loading requirements of individual customers. So it's on, you could think of it as almost a base infrastructure that the utility would have without considering any incremental demand of customers. So it would be designed to just provide access to customers or to the grid. So that's why we're saying that it would provide same benefits to all customers.
Okay, so I think, am I correct in saying that the statement here is that they should be treated as providing equal benefits? You're not necessarily testifying that they do provide, in fact, perfectly equal benefits. Is that fair?
So is the question if we have tried to quantify the benefits?
Correct.
No, we have not.
All right, if you could review, please, the pre-file testimony of Ms. Palmer, beginning on page 16, line 20.
Excuse me, sorry, I got lost. What's the page number?
Sure, the testimony of Ms. Palmer, beginning on page 16, line 20, and continuing through to page 17, line 2. There's just a few lines there. And once you found that, if you could just describe from your understanding of her testimony at a high level, how the suggestion by Ms. Palmer might be implemented in the company's cost of service model.
Sorry, reference again, starting with 20 to what?
Page 16, line 20 through page 17, line 2. So if you could describe at a high level how that suggestion might be implemented in the company's cost of service model.
Sorry, what was your question again?
Sure. So those few lines of Ms. Palmer's testimony, I'm hoping that you could describe for us how, at a high level, this suggestion might be implemented in the company's cost of service model.
So are you asking how mechanically we'd make the change to the model?
Sure. And one example might be how the company would calculate the total load carrying capacity of the minimum system. One piece of information that might be helpful.
I don't know if it's straightforward to calculate the load carrying capacity of the minimum system because, it depends on voltage assumption, what the current carrying capacity is, what power factor assumptions you have to make. So I wouldn't know how exactly you could make that change.
So maybe you can answer this, if it's possible to allocate the load carrying capacity of the minimum system to each customer class. Is it possible for the company to do that?
I'm still not clear exactly what that even means. Like the system, right? Like the load carrying capacity changes, and it's not a static sort of measure. You can just say, okay, here's the load carrying capacity.
Okay. Maybe a late file request is the best way to get some of this information. Could you modify OCC 362? There are 3 attachments to that, attachment 24, 25, and 26. Again, that's OCC 362, attachments 24, 25, and 26. To credit the minimum system's load carrying capacity for each customer class when calculating demand allocators. Is that something the company could do?
I still don't understand how to calculate that.
Hi, this is Graham Turk with the authority. I think my example here would be the actual distribution system has a load carrying capacity that you could associate with the system peak, the coincident peak of the entire distribution system. The minimum system is a hypothetical system, obviously not real, calculated for the purpose of the cost of service study. Does that system have a carrying capacity that could be allocated to each customer in order to calculate the total, each class contribution to that peak?
So in terms of for circuits, right, we have many hundreds of circuits, and each of them will have load carrying capacity. So how would we figure out how to allocate to customer classes?
Well, the demand allocators are the NCP and 1CP. So is there an analog for the minimum system where you could calculate the non-coincident peak and coincident peak affiliated with that system? I know it's not a real system, but is there a carrying capacity of the minimum system that you could calculate as part of the cost of service study?
So let me explain this back to you. So just so we understand the late file. So late file, what you're looking for is using each of the minimum system we picked, figure out what the load carrying capacity would be for each individual asset, and then figure out a way to assign that to classes. Is that fair?
I think that's close. I guess I'll first just ask, is there a minimum load capacity for each customer on a per customer basis? If you spread the total carrying capacity of the minimum system, is there a value per customer that you could then use for future allocators?
I don't think we have that at the customer level.
So I think the way you restated the late file exhibit based on what you've testified you can accomplish is it would be satisfactory.
Okay, thank you.
So it's late file exhibit 71.
All right, and looking at UI BR1, page 20, the company states that it uses the 1CP allocator rather than the alternative demand allocators because the allocator is simple to understand and is readily available. Why does the company advocate for this simpler approach if it's not necessarily more reflective of costs, even if the results are similar in the present case?
I'm so sorry. I lost the reference again.
I believe it's UI BR1, page 20. And so just to restate.
Can I make one request, please? Sorry.
Sure.
Let's get to the reference and then if you can read the question, that'd be very helpful.
Sure.
Okay. I'm sorry, I'm at the page.
Thank you. So what I'm curious is,
I don't have the line numbers though.
sure, I don't think I have the line number in front of me. I believe it's at 15 through 17.
Okay.
So the question is why the company is advocating for the simpler approach if it's not necessarily more reflective of costs, even if the results are similar in the present case?
It is reflective of cost causation, because when we, for the time of use period determination, when we looked at when substations are peaking, our conclusion was they are very coincident with the system peak.
So this simpler approach might, correct me if I'm wrong in this understanding, right? So in this particular instance, because those results are very similar, it might be more reflective of cost, but would this approach necessarily be reflective of costs in every case, or was it more of a coincidence that it happened to end up with the same result here?
No, I don't think it's coincidence. If you think about the distribution system, substations are one of the most upstream assets where there will be more diversity. So substation, the the distribution of when substation peak coinciding with when system peaks is not a coincidence. It is based on cost causation.
Okay, so your testimony is that it's not just that the virtue of this allocator is that it's simple to understand and readily available. Is it your testimony that it is the most reflective of cost option as well?
Yes.
I want to move on to the residential fixed charge and FERC accounts for a 584 and 597 for meter expenses and meter reading FERC account 902. And my question is, can you explain why those expenses decreased?
Would have to review the accounting information. We'd have to actually go into the FERC accounts and look in detail between what happened in the previous case and what happened in this case. We haven't looked at that on a line-by-line basis.
Okay. Would that be something that was relatively easy to provide as either a read-in or a late file, just a high-level explanation for why those decreases happened?
We prefer a late file.
Sure. So that would be a late file explaining why the meter expenses in FERC accounts 584 and 597 and the meter reading in FERC account 902 decrease with a high-level analysis of that accounting. And also, what would be the net effect of those accounts on the MRCC calculation? Could that be included as well?
Attorney Tanaka, is there a document in this proceeding that compares those two things that you're just referencing? Or are you asking that we compare the study in this case to the study in last case?
If I can point you to RRU 5 attachment 1, but I believe there was an update subsequent to that might have affected some of your numbers.
So we can compare the MRCC calculation from 220808 to this one, and we can look at the accounting records for those accounts from then to now. And I think that will give us the information.
Thank you. Yes.
Slate file exhibit 72.
All right. And in a similar vein, could you explain what types of costs are included in the intangible plant FERC account 303 and why it increased by 22%?
Well, it's all computer software. And we would just have to look once again at the assets that are booked to see why the increase was. There was, I think there were some customer journey software that was implemented, but absent a complete comparison between the list of assets included last time and this time, that we don't know, but we can do that analysis too, in similar vein to what we would do for late file 72.
Okay, so is that increase is or is not driven solely by the increase in rate base from the 2208 decision?
No, those, that's directly assigned individual assets. So we have to go look at the individual assets that were assigned one of the 4 statutory functions. And we actually have the information in both the MRCC full calculations there, and I just compare what the detailed asset line items are in this one to what the detail line item assets were in the 220808 MRCC calculation. Those assets are filed in the far back of, it was probably RRU 5 in this one where we show the full calculation.
Okay, so if we could add that as well to the prior late file.
Just all in 72?
If
That's fine.
So just what type of costs are included in that FERC account 303? And again, a high level explanation for why it increased by 22%. I have a feeling my next question might also be in addition to that late file. Can you identify the specific costs driving the increases to distribution, supervision, and engineering in FERC accounts 580 and 590?
We'll have to include that in there.
Thank you.
Attorney Tanaka, I'm going to go ahead and split those up. I don't think Lotus will give me much room. So
Understood.
let me just pause. Late file exhibit 72 will refer to the FERC accounts 584, 597, 902. And the high level explanation for the decrease, why the decreases occurred and the net effect on the MRCC calculation. Then I'm going to take the last question about discussing the type of costs included in account 303 and an explanation for why that account increased and make that late file exhibit 73. And then the most recent question, I'll make late file exhibit 74. And
What was the specific cost driving the increases to distribution, supervision, and engineering in FERC accounts 580 and 590?
Thank you.
All right, this next question, I would reference RRU 235 attachment 1. So RRU 235 attachment 1. And this is a simple question, I think. Is it correct that an overhead reconnect tap fee is charged when the company has to dispatch a technician in order to reconnect a customer versus being able to reconnect a customer remotely?
Yes.
Thank you. Can you explain the reason that the proposed fee is 35% more in this proceeding than the fee approved in the last proceeding in 220808?
Once again, we'll have to double check the detail behind that. So
Is it potentially a read-in for that? Just what's changed since 2023 that would require a 35% increase request in the fee?
I prefer a late file.
So would that be late file exhibit 75?
Correct.
Thank you. All right, and next I'd like to look at UI RP1, page 73.
We're there, thank you.
Thank you. Could you tell us what the company's estimated timeline and estimated costs beyond the 45-week proposed time interval for a draft proposal deliverable report from the system integrator is?
At this point, we're not aware of what that timeline would be. We have to wait for the system integrator to do the full evaluation of our existing systems and propose the optimal solution moving forward, at which point we would have a better understanding of the time and cost needed to implement the optimal solution they would identify.
Okay. Could you provide an update to the status of the RFP procurement for the system integrator?
Yes. We are expecting the RFP proposals back next week. And we're still on the line item 3.
Just referencing RRU 116, although I don't know if you'll need to find it to answer the question. Why is the company unable to provide cost and timeline estimates to implement end state rates under the option that involves upgrading its own billing system?
Again, as we stated, because we don't know what the optimal solution to implement the final system to do these end rate tariffs would be, we don't want to go down a path that could result in stranded costs and imprudent costs to our customers. Therefore, before we could do an internal change, we need to understand what the best solution would be to make, whether it's in our billing system or elsewhere. Hence, we're relying upon a system integrator to come in and do that evaluation and analysis and understanding the systems that we have, as well as the industry as a whole, where it's moving and the future of billing systems, and provide us with an optimal solution.
I see. So would it be fair that it's not necessarily that the company could not provide those cost and timeline estimates, but has elected not to while awaiting the results of the system integrators review?
Yeah, we do not have the cost at this moment. We are looking for the system integrator to come back and do the full evaluation of our systems.
And that RFP was developed in December 2024, is that correct?
That's correct.
And can you explain what the reason is for the timeline of that not happening until December 2024?
Well, it was identified to bring in a system integrator around November timeframe. And that's how we kind of started working on preparing the RFP.
Okay, so if we could take a step back then, what was the process by which you identified the need for a system integrator in November of 2024?
Usually, when there is a major transformation initiatives and a huge system impact, we go out and get a system integrator so that the integrator has a expertise in implementing similar solution in other companies. So that's kind of the criteria we follow here.
And how did UI, what's the decision-making process that UI went through to arrive at that decision?
It's an internal discussion. We did do some internal evaluations and talk to some of our peers in other industries and understanding the complexity of the change that required to be completed. And that's how we kind of decided to go for an SI.
Okay. And when did those internal discussions and internal evaluations take place?
It's around like a November timeframe.
November of 2024?
Yeah.
Okay. So the process began looking into this in earnest in November 2024. Is that fair?
Correct.
Now, does the company expect that billing and metering system changes that are recommended by an external system integrator, for example, being able to use interval data to compute billing determinants, would enable more flexibility in future rate designs?
Yes, that is our intention.
So for example, if the company needed to shift its end state on peak summer period from, I'm just picking numbers out of a hat, 2 to 7 to 3 to 8, what changes would you expect after the billing and metering system modifications are completed to be able to do that?
It would be relatively straightforward once we have the foundation up and running.
And is flexibility in implementing future rate designs one of the criteria that UI is using to decide on the best path forward regarding this billing and metering system change?
Yes.
Now, on page 60, lines 21 to 22 of your direct testimony, there's a reference that the company's proposal for aligning non-distribution rate components is illustrative. And I'll give you a minute to find that and I'll ask again. But we're just looking for some elaboration on what it means there, what you mean that this is illustrative. Obviously not the definition of the term illustrative, but in this context, what that means. So that's the direct testimony, page 60, lines 20 to 21.
So these rates are set in other dockets. And we anticipate that either an order will come out of this docket that will direct the rate design of those dockets, or orders may come out of those individual dockets that are informed with the TOU material that comes out of here. So we can't set those, or we're not attempting to set those rates in this docket, but especially in the RAM docket, because there's a lot of RAM rate design. There's a docket open for that already. We assume that the TOU portion of anything that comes out of that docket will be informed by what we're able to develop in this docket. But we will have the same metering information that comes for distribution rates in those other dockets. So, in those other rates. So, they're all interrelated. It's all rate design. We assume that we're going to take the rate design from here into those dockets, but set those rates in those dockets.
Thank you. Now, in interrogatory response, RRU 343, I'll give you a minute to find that. So specifically the discussion of the company currently recovering transmission and NBF MCC costs exclusively in the peak period under its existing time of use rates and proposing to keep this time of use structure in place for the near term time of use rates until it can implement the end state rates. Does the company believe that the resulting summer on-peak charge of nearly $1 per kilowatt hour, inclusive of all bill components, would adhere to a rate design principle of gradualism and customer acceptance?
Sorry, Attorney Tanaka, is that figure on any, is there a reference to the figure that they can pull to?
I'm sorry, I don't have
The
it up
value that you just
in
gave.
front of me. We'll have to look for it.
Take your time. Thank you.
Are you referring to the primarily driven by the change in the summer peak distribution rate? Okay.
So I was referring to the resulting summer on-peak charge of nearly $1 per kilowatt hour.
But is that,
So I asking if that charge would adhere to a principle of gradualism and customer acceptance.
the only charge we're talking about changing the rate design of on November 1st, 2025 is that summer peak distribution rate. Because all the other rates, the new rate design with the shorter peak hours, those are that's an end state rate design. So we'll have time to feather those into the billing system. What will happen on November 1st, 2025, is we can set that higher distribution rate over a period. We could set it and glide to it over, say, a 3 to 5 year period. So it doesn't necessarily have to jump from its current value of around 8 cents or so per kilowatt hour for rate RT to 32 cents all at once. So yes, gradualism would suggest that we phase that in over a certain period of time.
Okay.
But none of the other rates would change the design of on November 1st. Those are all end state rate changes.
Understood.
I would also like to add to that, if I may. Particularly with radar T, the summer on peak represents 10% of the annual consumption. So, you have to put this in balance of a customer's overall bill throughout the year. So that one rate component represents a small component of that customer's bill over the entire annual period. So when we talk about rate gradualism, we need to put it in context of how that impacts that customer's bill over the year.
All right. And I want to draw your attention to RRU 172 attachment 1, page 2. So that's RRU 172 attachment 1, page 2. And with respect to the response here that a rate R customer whose monthly consumption and load shape equal, sorry, I'm going to start that over again for a much shorter, hopefully, question. So how would the system benefit if the rates are to be set such that an average radar customer who enrolls on rate RT would save money without changing consumption patterns? Or perhaps more precisely, would the system benefit if rates are set in such a way that an average radar customer who enrolls on rate RT would save money without changing consumption patterns?
That's the current situation today, and it has been that way for many years. It doesn't necessarily benefit the system to do it. This is what the design, the proposed design of the rates of the end state rate should handle. There should be, and there has been for many years, a customer can save by going to rate RT and keeping their same load shape. The crossover point between R and RT is about 35%. So that's when we did this calculation, we're carrying on the transition to new rates using that 25% boundary. So right now, if we have a differential between radar and rate RT, that happens on the distribution side, we can't change the rate more than 25% either way. So that difference will persist for whatever transition time there is into the future. Ideally, we would like to see a combination of rate R and RT, that load, whatever that is, peak maybe is 25%. We'd like to see that be a revenue neutral so that customers who go to RT will benefit if they change their behavior. But the existing rate structure right now does result in people who move from radar to RT if they're near the class load. And when I say that by the class peak percentage, if they're near the class peak percentage, then yes, they will save money under the current rate design.
Okay. And under the current rate design, if all rate R customers enrolled on rate RT without changing their consumption patterns, would this result in an under collection of the residential class's revenue requirement?
I believe it would.
And did the company consider the principle of revenue neutrality when designing these time of use rates, the proposed time of use rates?
I think for the end state, yes. For the current rate structure, we're limited to changing by 25%. I mean, that is the limitation that was put on, I think back in 2013, that we wouldn't change any revenue allocation to a rate schedule by more than 25%. So we can't jump from the differential between radar and rate RT in distribution. We can't jump to no differential overnight. We have to get there, and by equalizing that over time, we should get there without causing undue shock.
So I need to jump in here as well, seeing I did the revenue allocations and the rate design at the present for the November 1 rates, which are opt-in. That's the proposal. There's no way for us to know what kind of customer acceptance would occur. So we just left the billing determinants as they are today. So there is a risk of over or under collection, And we've known that, and frankly, we have that risk today. I mean, that could happen at any time. So the changes to the proposed rates are relatively modest. I know there's been some discussion about the summer peak distribution, which may cause some customer movement, but we just don't know what the customer reactions will be. And it could cause over or under collection. And, the revenue decoupling mechanism will, in effect, cover that in between rate cases until the end state rates go into place.
Has the company done any research with its customers as to how their behaviors might change under various time of use rates that might go into effect?
Not under various time of use rates. That would require pretty sophisticated study. And we can't actually charge customers these hypothetical rates. So we don't know how they would respond in reality.
Okay. So looking at interrogatory response to RRU 385,
I'm there.
and I'm just looking to see if you can explain why the allocation of costs to demand charges versus energy charges for the GSTD rate has historically been based on the proportion of revenues collected from demand charge and energy charge under current rates, which ensures that the demand charge and volumetric charge recovers the same proportion of revenues under the proposed rates as it does under the current rates.
So is the question why we maintain the same ratio?
I think my question is, if you can, explain how this procedure became the procedure to be used.
That is what we had proposed in UI's previous rate cases.
Okay, so I think then my question is, what makes that a good proposal? Why was that proposed that way?
This goes back to rate design from a long time ago. Ideally, all these distribution rates would be demand-based. So we would have no energy kWh prices because there's no energy-related costs on the distribution system. We don't believe that that will be a rate design that will be accepted by a large number of people. So we need to have some kind of KW and KWH relationship. We don't for rate LPT. Rate LPT is solidly KW, but GS and GST have traditionally been KW and KWH. And we've maintained that because, like I said, I think that there would be quite a bit of resistance if we eliminated the KWH charges and just charged all based on demand.
Okay, so fair to say that this is more history and what you believe would be accepted as opposed to a belief that this is the ideal metric.
Correct.
Just to supplement what Mark said, because GST rate is designed for load factor customers, that's why we have energy component in the rates.
Yes, you do get extremely high average revenue per kilowatt hour values for low load factor customers. That's the EV problem that we've solved to some extent with the EV rates that we have. But yes, that's a problem for low load factor customers, and there could be quite a few of them.
If I could just have one moment. Just wanted to circle back to make sure that I'm clear on your testimony. Could you just explain the 25% limitation that you were referring to a little while ago?
I know it was Mr. Kolk's testimony, but I'll jump in because it really relates to my direct testimony exhibit. It's actually the direct testimony exhibit UIRP. I have a bunch of exhibits open, forgive me. It's, I believe it's RP3, revenue allocation. And the percent, the 125% is just the percentage increase over the average increase. And then there's 75%, which is the minimum kind of threshold. So we have a kind of like a regulatory bandwidth that we work to. And in the previous docket, that bandwidth was upheld. There was some discussion about rate of return being, class rate of return being the more important metric that we use for revenue allocation, and then this bandwidth being second. But we do really respect this 25% over the average increase, and that's what Mr. Kolka was referring to.
Thank you. If I could just have one moment. I believe that's all the questions I have for today. Thank you.
Okay. Thank you. Let's transition into cross by the Office of Consumer Counsel, please.
Good afternoon to the panel and to the commissioners. Claire Coleman, Office of Consumer Counsel. I have a couple questions that seek to sort of integrate the time of use rate proposal of the company and the discussion around AMI and the current state of AMI technology. Your testimony references the AMI metering in place and the AMI final plan that was submitted, I believe, in November of 2024 in terms of its relevance to the time of use rates. So I just want to make sure I understand that intersection. So the AMI plan, which for purposes of the rate case is UI SIP 8, the company states it's more than 90% done with AMI meter deployment and expects to reach 100% by the end of 2026. Is that accurate?
That is our current plan, provided we have sufficient funding from this rate case to follow through with that plan. Yes.
Okay. And with that 90% deployment, could the company describe generally how the AMI meters are being utilized currently? I know that's a broad question. I'll go through a couple examples that I think were in your plan. I think you indicated you utilize the AMI meters for remote meter reading
That is correct.
and improved outage management.
That is correct.
And is there utilization of the meters for DG or DER monitoring?
It does measure the output of a DG in the net amount, or if we have it metered for the gross amount, yes.
Okay. And do you utilize the meters for measurement and verification of any of the demand management and energy efficiency programs?
Most of our demand management programs are run by vendors for us. We can use it to validate that, yes, not immediately. It's typically after the fact. So we would be approached by our CLM team to say, an event was called yesterday. Can you provide us the data to validate that the customer did indeed reduce usage during the period of the event? So we can provide that. It's not a real-time event monitoring.
Okay, so you have the technical capability. Have you been asked to utilize it in that way in the example you just described? So sort of on a case-by-case basis? If
Yes,
a
it is.
vendor asks you. Okay, great. And then, in terms of benefits of the AMI related to time of use rates, it appears from my reading of the statements in the plan that the company believes the benefits of the time of use rates are already being achieved with the current AMI technology?
Yes, that is what we stated.
I saw that the AMI plan was required to respond to the list of categories that Pura had included in its final decision. And one of those specifically related to time of use or time varying rates.
Correct.
Sounds like you remember you remember this. The benefit cited was load balancing and more accurate load profiles.
Yes, in
and
comparison to the AMR metering that we had in place previously.
Prior
Or
to that.
previously to that, when we had to walk up manual metering.
Okay, so when in that column, in that row, UI indicated that, quote, both residential time of use and TVR rates as well as commercial TOU rates have existed for many years. There are no incremental benefits to track.
That was referencing to the fact that we have 10% more of our meters to deploy, that the vast majority of the customers who already have an AMI meter are benefiting from these. The vast majority of the customers that do not have an do not have an AMI meter currently would not need an AMI meter because they're not in any of those programs. So for instance, if you're going to be driving your Camry to the grocery store to get groceries, you don't need a NASCAR vehicle to get there. Whereas if you're going to be competing in NASCAR, you need a NASCAR vehicle. You don't want to drive your Camry.
Okay, so analogizing NASCAR to AMI technology is sort of, I guess, different versions of time of use rates. I think so. I think I'm trying to reconcile the statements about the benefits of the time of use rate proposal of the company with the statement that there's no incremental benefits to track. And I think, is it fair to say that it's UI's position, your current AMI technology has the capability to deploy the more granular time varying rates or time of use rates proposed by the company, which are the basis for the incremental benefits discussed?
Yes.
Okay.
Currently, our AMI meters are able to collect 15-minute interval data from all of the customers that are AMI metered. From that, it is possible, whether it's through a meter data management system change or a billing system change or some other change that we're not currently aware of, that a system integrator will be able to come forward and inform us the optimal solution to implement the end-use rates. But the interval data is available to implement any future time of use rates on different time periods. So the infrastructure is there, the benefit has been obtained. There is no real major change. In fact, there's no change to the AMI system that will be needed. It would simply be an integration and a system process after the meter, whether it's in our meter data management system or an SAP or some other solution. So the AMI solution is, as it stands, is capable of supporting.
Okay, so I'd like to tease that out a bit because it does appear, if I'm reading your testimony right, that there are some additional investments needed in order to effectuate the time varying rate proposal that you just, I think, listed some of those.
Right.
But you're distinguishing between the actual AMI meter technology and the like communications and the other sort of
Yes,
add-ons.
that is correct.
And then I don't know if you'll know this, but we were trying to figure out in UI's planned plant additions, it's CIP 6, there's two different references to metering and the first is UI CapEx meters and the second is UI smart metering.
Yes. The
Okay,
difference is the CapEx meters are the procurement of physical meters. So we discussed this under Chuck Eves a
right.
couple days ago, where we're actually purchasing meters for our planned deployments for various reasons. So that is the CapEx purchasing of the meters. The smart metering programs are the systems that support AMI data, whether it's our meter data management system, whether it's our MV90 system, things like that, upgrades to those systems, network maintenance on the AMI network devices. You know,
Okay,
those
so
get
it
hit by-
sounds like those additional investments necessary that you referenced, the billing changes, the MDMS system changes, those would fall within the UI smart metering line item.
Not necessarily. If it's a billing system change, that would fall into our CIS SAP billing system under the IT organization. And any future changes to the meter data management system, though, would fall into the smart metering costs. But as we do not know what those could potentially be, those are not currently captured in this current rate case.
I see. Okay, so because you don't have the specific, because the cost depends on the specific time varying rate or time of use structure that is
And the-
ultimately imposed.
And the potential solution that would be optimal for going forward to support all the future positions.
Does the company have a range or an estimate if?
We have no idea at this point. We're waiting for our RFP to complete so we could look from a system integrator and have that system integrator perform the analysis of all of our existing systems, as well as bring in their knowledge of the state of the business and billing processes moving into the future, and the best way to support all future rates and needs being requested. After we have that information, and they would provide us with a solution to optimally implement for future TOU rates, then we would have an idea of the time and cost needed to implement that optimal solution.
And did I hear in your conversation with Attorney Tanaka that you believe the results of that RFP are coming back next week?
Yes.
Or at least the first responses are coming in, and we have the evaluation process and determination of the solution, of the system integrator select. And once the system integrator is selected, then we have an additional time period for which they will have to do their analysis.
And based on that information, would you be able to provide an update to, I believe it was discussed in EOE 94, the RFP process with respect to any additional cost estimates the company might be able to pull together from that?
Yeah, when we complete the process around Q4 this year, we would be able to give some high-level estimates. What would be the future cost would be.
Okay, that's.
Obviously, that's
after the-
outside this rate
Right.
case.
Right. I mean, I recognize you're not able to share results before you pick a vendor and there's some confidential information in that, but I just wonder if the company would be able to extrapolate ranges just to give us a sense of what types of costs we're looking at.
Thank you for your patience. Based on the analysis of the information that we receive next week from the various solution integrators that we would be evaluating, we could inform authority as well as OCC what expected costs would be for the analysis and review of our existing systems. That would be something, that's a first step.
Right.
But we would not have great detail as far as the costs and time necessary to implement the final system changes at that, until beyond the terms of this rate case.
Okay, I appreciate that. And I think any additional information you could provide would be
could-
helpful. I think we could do it as a supplement to EOE 94 or make it a individual late file exhibit, depending on the authority's preference.
Thank you, Consumer Council. Mark that late file exhibit 76.
Great. Thank you. So then just, you've also discussed briefly with Attorney Tanaka, the billing system changes needing, and I just want to make sure I understand the testimony currently, which, as I understand it, states that the existing billing system is not capable of billing customers using interval data, and the current meter data management system that we just discussed is not able to register reads from interval data to be used with billing. So I'm just.
Can you provide the exact reference, please?
I believe it's page 70 of the rate panel testimony. Pull it up to confirm. Faster than. Yeah.
I'm there, thank you.
You're there, great. So could you just explain this a little more? For example, how do you bill someone for time of use now, and what is the billing system change specifically that is required?
Okay, certainly. How we bill today is the meter is measuring the electron flows continuously and determining if that is flowing into the premise or coming out in the case if they have a generator. And it's measuring that, and it knows the system time. So knowing on what time it is and which direction those electrons are flowing, it calculates the watt hours that are being used or provided back to the grid from a GG, and tracking those in time of use buckets that are saved in, I call it a bucket register, multiple frames for it, tracked in the meter based on the time periods that are programmed into that meter to measure for on-peak, off-peak, shoulder peak, depending on the customer's tariff. So if a customer is on a tariff which has on-peak, off-peak, shoulder peak periods, the meter is programmed to have those specific hours measure the usage into those time period registers. It's measuring not only the kilowatt hours, but also the kilowatt demand in a 15-minute block. So it's providing that information to us per day. And I'm sorry, what was the second part of your
Well,
question?
and I guess so with the upgrades of the MDMS system, what would the new methodology be?
Well, we don't know what the new methodology
Still
would
have to
be.
test.
So I would not hazard to guess what the future may hold.
All right, and then in response to EOE 95, you also stated that to implement time of use, you either have to reprogram or replace every single meter.
That is correct.
Okay. It sounds like you tried an over the meter or over the air meter reprogramming pilot, but that didn't work. Could you give us a little more context on that?
Yes, we identified when reprogramming a meter over the air that it resets the meter entirely. So it sets it back to zero. So similar if your car odometer, if you go in every time you change your oil, it resets to zero on your odometer. That would not necessarily be a good thing. In fact, that would be very bad. And so what happens with our billing system is if the customer's prior reads, and I'm just going to use some picked up numbers, was 50,000 and they were on a rate R, and then the next day their read is zero, the billing system will assume that they used 50,000 kilowatt hours to roll that meter over to zero. Just like with your odometer, when you go over 999,000 now, you get to 1,000,000, but it starts back at 0, 1. So in the metering system, or the billing system, I'm sorry, when that meter gets reset, it suddenly bills the customer for an exorbitant amount of usage that did not occur. The only way to fix that would be to change the meter out in the billing system to show that the meter was exchanged. We do not have workflow processes to do that for a virtual exchange where the meter is not actually removed in the field. When we attempted to do that manually, we identified that if you remove the meter and reinstall it in the billing system on the same day, that it doesn't work. It needs to be done. The IT removal and the IT install have to occur on physically different calendar days in order for this process to work properly, because the billing system as well as our MDMS system is looking for a removal or an install on a day. And if you try both of them, it can only accept one, so it throws out the first one and keeps the second one, which is I'm installing the meter, but it says you already have the meter installed there. There's no problem here, ignore it all. And therefore, it still bills you for fake usage that didn't actually occur because the meter rolled over. So that's why we decided not to do that, because we felt that our customer shock to seeing these improper bills would be horrible, and you'd be receiving calls and Pure would be receiving calls.
Understood. So with a manual reprogram, you would avoid
No, we have
multiple stages, or do you still need multiple days to complete the
manual reprogram of the meter. We would basically be exchanging the meter and then reprogramming it back in the shop.
I see. Okay.
You can't just walk up to a house and reprogram the meter. It does the same thing, and then we have the same problem with the workflows that don't support.
So the customer would have a temporary meter, you would swap it out and
No, we would physically exchange the meter. That would be the optimal solution to reduce the number of visits to the customer's residence. So we would just come exchange the meter, reprogram it in the shop, and then
use it for
use it
someone
somewhere
else.
else.
Okay. Which is different than a full replacement of the meters. That's the
Typically, a
distinction.
replacement would be for a failed meter or some other reason that the meter is not functioning anymore. That would be a replacement, not just an exchange.
And despite the complex process you just described with reprogramming, is it safe to assume that reprogramming is less expensive than full replacement?
To an extent, yes. The difference being that with a replacement, we have a meter that might still have an asset life available, but is no longer functioning. And that's what the situation we have with the supercapacitor issue that we discussed previously with Chuck Eves, where the meter is physically failing. So a replacement is when a meter has failed. However, because of group depreciation that Ms. TheBurge has testified on previously, and I would not dare go into the details of, that kind of comes out in the wash. Whereas an exchange, simply that meter stays in service and is reusable and there is no issue.
And are those estimated reprogramming costs incorporated to the UI smart meter plan capital line?
No,
at this
because we
point?
don't think that that is currently the optimal way. We could be wrong. We're waiting for our system integrator to inform us the best solution. Excuse me.
Understood. So then, just to talk a little more about that system integrator, that UI, identified in its testimony as I guess, when did, the company first determine it needed this role?
It was determined around November last year.
Is it in the context of evaluating the time of use rates, in this rate case? Okay, that makes sense, because I didn't notice a reference to it in the final AMI plan, so I was just wondering if, at that point you knew that, an integrator would be helpful.
No, in the final AMI plan, we were recommending no change to our existing time of use periods, as well as remaining opt-in for our residential time of use period for the AMI plan. It was only through the preliminary review of this docket submissions for time of use changes that we evaluated that we probably need to look at a different solution than what we have.
Thank you. And it sounds like the system integrator is required to be in place to kind of pull together this uniform plan and related cost estimates. I think you and Attorney Tanaka talked about it a bit, but can you just remind me of the endpoint of when all of that will be available to the company?
it would be around Q4 2025.
Right, that's what you said. Thank you. Okay, just stepping back a little on the time of use proposal generally. Would the company agree that a well-designed time of use rate or time varying rate can be an effective tool to reduce peak load? Start easy.
Yes.
Thank you. And in terms of different time of use rates or time varying rates, would the company generally support, I guess, well, let me step back a sec. Is it possible to have a time varying rate program where you have time of use rates as well as time varying rates like critical peak pricing in the same program?
Yes, they can be complementary, yes.
And I think you kind of gave me the answer by saying they're complementary, but do you think using those tools in combination could increase the effectiveness of the demand reduction impact?
Yes.
And are you familiar with any programs where critical peak pricing has a higher differential and then the more basic time of use rate has a lower differential?
That's typically how they're constructed, yes.
And in that scenario, would you agree that that combination could increase the effectiveness of both customer response and the peak demand reduction impact?
Yes.
So I don't have the reference here, but the company's response to Ms. Palmer's recommendation that UI should identify cost drivers to inform the selection of periods and seasons. Believe there was a statement that quantifying those drivers is not, quote, as straightforward as implied. So I just really wanted to understand that a little better, whether the concern, what the concern with quantifying those cost drivers are.
So that statement was made in the context of if UI was a vertically integrated company with full service where we were providing pricing for generation transmission, we own the asset, and it's much sorry, I lost my chain of thought.
That's okay. So recognizing UI is not vertically integrated, there is nevertheless some role that UI plays with procuring standard service, correct?
Yeah.
Okay. So I'm trying to figure out, is the concern related to relying on forward-looking forecasts or setting an initial rate differential utilizing, recent experience in standard service or supply costs?
I believe the main concern was that UI does not have visibility in terms of other components outside of distribution. Because we have the full revenue requirement, distribution is in UI's book, so it's much easier. There's clear line of sight in terms of what the distribution revenue requirement and cost recovery is, versus for other components, there isn't as much compared to if UI was vertically integrated.
Okay, but could UI in its current position look at, for example, historic data about seasonal supply pricing and integrate that into cost driver estimates?
That those would necessarily need to be set in a supply docket. So what it sounds like you're talking about is doing a rate design on standard service or last resort service, which that has complications of its own. We We don't know what the LMPs are going to be. Those would have to be forecasted. And if the forecasts were wrong, who bears the risk for that? And if it's not being offered in the competitive market by putting into standard service, does that itself become anti-competitive? These are questions that we'd have to ask if we're going to look at embedding all this stuff into the standard service.
Thank you for that. I don't think I was necessarily intending to focus on applying this to standard service so much as using the information in order to inform the selection of the periods and seasons, and just trying to figure out to what extent both historical supply data and, any forward-looking could be utilized to make sure we're setting those as accurately as possible.
I think Mr. Ramal did a pretty extensive look at that.
Right. So I think that correct, but then when I think when quantifying, so is it correct that UI's testimony about quantifying drivers not being as straightforward, it's specifically related to the supply component? Is that?
Yeah, so,
Okay.
yep, non-delivery components.
Okay, all right. I understand that now. Thank you. Moving on to the customer education plan portion of time of use rates. So the company has a list of proposed sort of action items that it intends to take with respect to customer education on time of use. They are in the customer service panel testimony, but hopefully there's some familiarity here with them.
We've
Could
discussed it, but they are the experts in that.
Okay. So is it fair to say that what's captured in the customer service panel portion is the full extent of the planning that UI has done with respect to time of use education?
Yes, the rate panel has done none itself.
There is also information filed in the AMI final plan around education and outreach,
Okay.
the capital filings.
And is there any other information, like does the company have any kind of customer engagement plan apart from what was in the AMI plan, a separate document, for example, that you might be able to provide us?
I agree with my colleagues that I think a coworker of ours on the customer service panel is probably best suited to answer that question, but recognizing that they're not here today, we'd be happy to take that question via late file and get back to you if we have anything further to offer.
Okay, that's fine. There's one particular, well, sure, I guess, if the company has something in writing that is specific customer engagement plan for AMI, I would request that be provided. I'm assuming the answer is no, you don't have that.
That would be my assumption too, but we'd be happy to check and.
Okay, do you want to read in rather than create another late file, or how would you like to handle that, Chair? That confirming whether or not there's a document in writing?
I'm just not sure when we'll be able to get in touch with this colleague, so I just want to give us the maximum opportunity to respond to your fair question. If that's okay.
Sure. Thank you. That is late file exhibit 77. Or sorry. Yeah, 77. Yeah. Great. And then just to follow up that I believe this panel can answer. The first is, would the company support implementation of a bill comparison tool like shadow billing? I did not see that on the list of the customer service testimony, so I just wanted to specifically address that.
That also may require conferring with some of our customer service colleagues who are not here today. We'd just be hesitant to commit the company to something that its customers may care about without checking with our customer service colleagues. Would you be okay if we took that via late file as well?
Sure. And then you may want to consult with them as well for this, but I wanted to know the company's position with respect to engaging a third party to assist in the development of a robust customer education plan. Would the company have, be opposed to that or be amenable to it?
I think similar answer. I suspect we can get you one. I'll just want to confer with my colleagues. And to the prior question you asked about shadow billing, candidly, that term is not familiar to me, but I'm guessing based on the fact that you've used it, it might be familiar to my more expert colleagues on this topic.
I think I saw Mr. Therian nodding, so he can explain it, but the concept is
Knew
that
you were gonna call me on.
you show different alternatives. That had your rate design be X, your bill would have looked like this. So
I understand.
it provides a live comparison.
That's helpful. Thank you.
For a bit of clarification on that also, it's a historic period. It's not a forward-looking period, typically, that analysis. So it would look back for a prior period, whether it's 3 months, 6 months, 1 year. It will not necessarily have any impact on future because of the fact that future usage is unknown. I just want to make sure that that's clear on record.
Great, thank you. And Consumer Counsel, what was the third component? Whether the company would support allowing or engaging a third party to assist in the development of a customer education plan? Okay, I think we can group those all together as late file exhibit 77. Great, thank you very much. And I believe those are all my questions, and turn it to Attorney Wheel.
Hi, Tom Wheel for the Office of Consumer Counsel. I just have a couple of quick follow-ups on AMI. We talked a bunch, well, you talked a bunch about the system integrator today. And I noticed system integrators were cost components in a couple of capital projects. Is the cost for this system integrator being capitalized in a project or program?
Your question, Attorney Wheel, to paraphrase, is are we seeking the cost of system integrator in this rate case?
Yes, but I am also curious whether it's in this rate case, and yes, we'll start with there. Yes.
I think we'll have to take a read-in to confirm.
Okay.
A read-in?
I think so.
Okay, we're up to read-in HH.
And yeah, if that could just indicate my expectation based on what I've seen from other things is that it would be capitalized. So I would also just be curious if it's in, like, if it's within a program or project that's within the interim period plant versus like within rate year plant, if that makes sense.
I gotcha. Yeah, if it is in the case, I expect we'll be able to point you to the plant model citation with I forget the name of the label from the capital investment panel, but it'll show the
SIP
dates.
3 versus SIP 5 for the.
Yeah, all of those good letters.
Okay. Thank you. I think I kind of heard some discussion about this, but I'm not sure if the question was asked directly. Why did the company determine that it needed an outside vendor to evaluate the AMI system in order to integrate the TOU rates?
My colleagues are experts in running the systems that we have, but we are not necessarily aware of what's going on in the industry. So in order to not just look at the systems that we have. And while we could sit down internally and kind of come up with, well, we have these blocks, what can we build with them? Perhaps we need additional blocks. And we wanted to make sure that we're making a prudent investment that is positioning ourselves to serve our customers into the future. It may be, excuse me, that the blocks that we have now are sufficient, but we don't know. And therefore, we're trying to get a system integrator who can come in and tell us the state of the industry and their views of the future, as well as what we currently have to identify the best way to implement the future.
Okay. Thank you. And my last question may be the same question as the read-in I asked, which is Consumer Counsel Coleman was asking some questions about the distinction between the CapEx meters and smart meter program. And it's my and those questions were specific to the future that's to be determined by the system integrator, the future potential impact, which is unknowable now. And I think Consumer Counsel Coleman was asking whether it's whether capital work pursuant to that future would be booked to the smart meter program. And I think I heard Mr. Lopik, you say that that's possible depending on what the work is.
Correct. If the work would be required in the meter data management system, then that would fall under the smart metering program for upgrades and changes to that. If it were to fall into our billing system, then it would fall into that area. If it happened to be a meter solution, then it might be into the CapEx metering side.
Okay. So my question is just, and I think I already know, but just to be sure, there's like 1.16 million in the smart meter program in SIP 5 requested for rate year plant. My understanding based on the support in SIP 6 is that that's accounting for work that's already been determined needs to be done. So that's not inclusive of anything that's going to be coming.
That is correct.
From, gotcha.
Yes, that work that is currently in the smart metering program are upgrades to our existing systems to maintain their service life as well as functionality.
Okay, thank you very much. Attorney White's got some questions.
Kim White with OCC. My questions are shorter and much easier. I'm going to refer you first off to Schedule E 2.5. And I got one question about it in general, but as you're going there, my first question is, do you know if the company filed a working copy of this with the formulas intact? It's your bill frequency analysis.
Not a numeric copy, just that was in PDF.
Okay, then could we please request that as a late file exhibit?
Yes, late file exhibit 78.
Right. So we would want unlocked copy formulas intact, please.
To what level? The PDF with numbers or the billing data? See, I believe that we can output from our system that bill frequency report in Excel. And that would be what you're looking for, or is there something, a level of detail greater than that?
Reproduce it. I'm going to say back to you what I think I heard you say and just make sure I understood you. You can reproduce what is Schedule E 2.5 just in an Excel version, or you're saying you could do it in an even greater detail than reflected in E 2.5?
No, what we can produce is what's shown on the PDFs and E 2.5 as Excel files, but that shows the summary bill impacts that, or the bill frequency. That's the level that we can show. So it'd be like turning those PDFs into an Excel file, but no additional information.
But would that have the formulas in it if you're doing that? We're looking for the formulas to be intact. So I guess I'm getting a little lost in our conversation here. I'm
The
sorry.
formulas for what, like the consolidating factor formula and those kind of things, or the formulas behind what?
Yes, if you could get the consolidating factor formula, that would work. Is that not?
I'm sorry, could you repeat that?
Yes, if you're offering to do it with a consolidating factor formula, that would be preferable.
Yeah. Well, it will put out just the number. We can describe what the consolidating factor is, but we can't put that consolidating factor equation into every cell. Because this is an extraction of an automated process. It's not like somebody's going into a spreadsheet and like our rate design spreadsheets here where you see all the formulas. This is literally a huge data extraction from a large system. And it's going to show just the results.
Okay, then could you just file the Excel version that you were requesting earlier with a narrative explaining?
Yes.
Okay. And it's not possible then for you to back into any of this then?
Well, I mean, there's thousands and thousands of lines there.
Okay.
Um,
Then if you could give us the narrative, that would suffice.
Correct. So I have it described as provide an unlocked working copy of the bill frequency analysis and a narrative explanation of the billing determinants. Is that what you're looking for?
That's good. Thank you. And looking at the PDF schedule E 2.5, it looked like when I was looking pages 13 to 14 that the March 2023 data for rates R and RT was not there. No, I'm just saying the data's missing.
It's missing.
All of March of 2023.
Right, then we'll have to supplement. I mean, we can file that, but I don't know how we file it, whether it's a late file or a supplement to the schedule.
Which schedule is it?
This is schedule E-2.5.
Attorney Vaughn, would that be captured in late file exhibit 1?
I was going to say that it may be captured in late file exhibit 78,
Okay.
if that makes sense. But
Because you're providing a working copy.
yeah, we
schedule,
will
yeah.
have, we'll have the SMEs go back and review it and make sure that we, have those in there.
And just to make sure, Attorney White, it was just with respect to residential customers?
Right. It was rates R and rate RT.
Okay, because I did see.
And it was March of 2023. Yeah, later on, there are the business customers. They're reflected for March 2023, but not the residential customers.
We had not been planning to provide this in LFE 1, but I assume we can provide it in LFE 78.
Okay.
Okay. And then my final couple of questions, I'm going to be referring to your rebuttal, but I don't know that you know. I'm referring to something you said on page 5, but I don't know that you necessarily need it. So in the rebuttal, you specifically stated that if the load in a service territory were reduced, but the number of customers was unchanged, you wouldn't expect the number of the poles or the miles of the wires to be reduced in the same proportion. So my question is, if we're kind of following through on that line of reasoning, if the number of customers in a service territory were reduced, but the geographic footprint were the same, how would you expect that to affect the number of poles and wires? Would you expect the number of poles and wires to be reduced the same proportion by the decrease in the customers?
are the customers in your hypothetical scenario, are customers completely leaving?
But when the customers left, they're leaving that geographical territory?
Yeah.
Yes.
Well, it's in instances if there's removal of property or if there's some dedicated lines and poles that just serves a particular house and that, well, if the infrastructure stays intact, then the answer is no.
So the answer is you would not expect the number of required poles and wires to be reduced in the same proportion as the decrease in the customers? You're saying it would stay the same?
Yeah, if we're not physically removing any infrastructure.
Do you know of any evidence in the record kind of describing the proportionality between the number of poles and wires and the customer count?
Actually, if you go to page 6, lines 9 through 13, where I cite NARC manual, there's that statement that you're looking for.
Thank you very much. That concludes OCC's cross.
Thank you. We're going to break until 3:35, and at which time we will resume cross with the EOE, please.
That where was she and wait, so I know exactly what you're talking about. It was like, oh, not everything was swallowed. Yeah. Yeah, you gotta take some like I do it, in the hearing room, you gotta take it pretty. Yeah. Hearing room in New Hampshire, I don't do. Or they line.
Yeah.
Per hour.
I didn't see you do it.
I get that. That was his problem. I actually, my buddy and I were, he's giant, his giant legs. But like, but if once everyone. Yeah, we have no hope after, right after the crash, during that. There's nothing worse.
All day. At least stand up, move around, you're just there, right?
How we doing?
No, we don't.
Yeah. Okay, let me see what I can do. Benjamin, doing a great job.
Thank you.
Especially with the building blocks in the future. We don't know. That was a great freaking answer, by the way. It was.
I'm trying to prepare.
That was a good one.
I had a long story I could have brought in.
No, that was
It's needed
good.
at this
That was
point,
good.
so
After the Toyota, I think, you had to back
Yeah,
off a little bit.
I
That
tried.
was or whatever. What was it, a Nissan or was
I
it?
said a Camry and a
Oh, Camry,
NASCAR.
right, okay,
Yeah,
right. Camry and NASCAR, that's my. Oh, it's a long day, sorry, but
Not that bad.
all good.
I don't know. Yeah. So far.
No doubt Jacob to the rescue.
So far.
Yeah, Jacob, that is good find. I kind of.
Yeah, that's no problem. I don't care.
Yeah.
Totally.
No.
Born bright. That's cool.
Well, that's a great question. I don't know the answer to that.
Yeah, so.
But that's fine. We can switch. Yeah, unplug me.
Sorry I didn't come out, but my wife wanted to talk.
That's good.
Yes. Oh, yeah.
Right, we'll go back on the record. Attorneys Vaughn and Hum, anything before we begin?
No.
All right, Attorney Spinecki.
Good afternoon, Chairman and Commissioners, Council and panel. My name is Jamie Spanhake. I'm a staff attorney with EOE. My first question is regarding EOE 89. If you want to let me know when you're there. Okay, so I have a follow-up question regarding your response to this interrogatory, which asked about the different results of measuring the ISO New England and UI distribution system peaks. So you'll see in your answer that the company answered this interrogatory by explaining the geographic differences between the two distribution systems and what they measure. But that wasn't exactly what I was asking. So I thought maybe I could ask the question differently and explain why I was asking the question to help our conversation. So I'm trying to understand how the differences in the system peak results as measured by ISO New England and the UI distribution system peaks lead to the specific on-peak time periods that you've recommended in the rates panel testimony. So I'm really asking about the methodology and how those two measurements came to your recommendation.
So as discussed in our testimony, we analyzed those hourly loads separately for UI distribution system, separately for ISO New England, as it was one of the requirements from the last order. So basically, we looked at when the peaks are occurring, what hours, what month, to inform what the distribution of the peak looks like for both. And then we also calculated a probability of peak analysis, where we looked at we'd pick an hour in a certain month and then look at what the probability was of that particular hour being the peak based on our historical analysis. We have that both, that's chart 13 and 14 of UI RP1. So that also informed us in terms of which hours are the peak concentrated in.
Okay, so would it be fair to say that those two charts that you just mentioned are the underlying methodology for how you came to the recommendations for the time periods?
Those are one of the methodology. I mean, the probability of peak was one, the other was shape, as I discussed earlier, shape of the hour, just looking without any statistical inferences. We just looked at the shape of the hours and then when the peaks were happening as well.
Okay, so would it be fair to say that all of the methodologies that you relied upon are in the testimony or somewhere other where some other place in the record currently?
Yeah, they should all be in the testimony.
Okay, all right, thank you. My next question is regarding the timeline, which OCC and Attorney Tanaka, I think, have both asked questions about already. But the timeline for what the company refers to in the rates panel testimony, which, as you know, is Exhibit UI RP1. If you want to pull that up, I'm going to be looking at page 73. So you refer to the significant modifications to the company's billing system needed to implement any new rate structures or time of use period changes. And then, as was discussed earlier, EOE issued several interrogatories regarding this timeline, and I'm specifically going to look at EOE 94 and EOE 178. So I just want to lay out some of the facts to inform our conversation from your responses. So Originally, in UI RP1 at page 73, lines 2 to 4, the company stated it planned to issue the RFP for the system integrator consultant around the third week of December 2024 and expected responses by the third week of January 2025. And then in response to EOE 94, the company stated it intended to complete the RFP process, including bid evaluations, by April 25th, 2025. And then most recently, in response to EOE 178, the company stated that it had not yet issued the RFP and that it intended to issue the RFP on March 31st, 2025, and complete the RFP process, including bid evaluations, by June 13th, 2025. So my question is, given the long time frame within which the company has known that these kinds of changes might be needed, why were there these delays?
Let me clarify just one quick thing. I did respond to Ms. Coleman question incorrectly. We did started the process, internal discussions around September 2024. And we got to pull together, team of people, talk to some of the, the other utilities, getting an idea. So it took us, a month or so to pull together a team. So we kind of went through the process, the procurement process. So our process has so many steps involved in onboarding a PM, and then there is a bunch of checks and balances. That's kind of where it took us, to release the RFP on 4/28. So we released the RFP on 4/28, and we're expecting the response back next Monday. Usually we give them 2 weeks to respond.
Mhm.
So I just want to clarify.
Okay. So I guess my initial question is, would it be fair to say that the company was aware that these kinds of changes to the billing system might be needed as a result of the decision in 220808? And I say that because in that decision, the authority, there were directions and orders regarding time of use billing and what would be proposed in your next rate case, which is what we're doing now, right? So I'm just curious, because that decision came out in August of 23, why the company waited until, I think you corrected yourself just now and said September of 2024. Why, sort of a whole year passed before any of the preliminary steps took place?
Can you give us a minute?
Sure.
Thank you for the patience. I'll start and then I'll invite my more educated colleagues to add on as they see fit. But I understand the billing system is tremendously complicated and the challenges associated with not being able to bill customers or sending out incorrect bills are things the company takes extremely seriously. So we wanted to make sure that we took our time and had a cogent, intelligent, and rational effort that would deliver the changes Pura described in the least cost, most efficient way possible. And we took our time to make sure that we got it right. But I'll let my colleagues add on to that as they see fit. Apparently I nailed it.
Good work. So would it be, do I understand correctly that you're saying that the company didn't necessarily realize it needed a system integrator until September of 2024? Is that what you're saying?
Correct.
Okay, great, thank you.
One moment. I think to add a little more color, and some of my colleagues are checking a couple of one of the dates that I'm about to say. We began working on the proposals we're making in this case well in advance of September. The time of use rates and various rate design proposals that some of my colleagues here are speaking to took a tremendous amount of work and a tremendous amount of effort. I do agree with my colleague that we only made the decision to proceed with system integrator at the time that he said. And I was making such a serious point too. We began working on our response to Pura's directives far sooner than that. I agree with my colleague that we only made the decision to proceed with system integrator at the time that he said, but I don't want to leave EOE commissioners, Pura staff, or anyone with the impression that we sat around waiting to respond to Pura's orders. And until that time, we put in a very serious amount of work to respond to the orders that we were given. And as I said earlier, we take maintaining an accurate and reliable billing system very seriously. So we wanted to make sure that we'd crossed our T's and dotted our I's before proceeding with this work.
Okay, thank you.
And to add on to that, as part of our AMI filing, final AMI plan that we submitted with this rate case, we did have to do some outreach to stakeholders. So beginning in early spring, late winter last year, we started developing queries to our customers and involving stakeholders to look at potential designs for a new time of use tariff as part of those dockets. So we were doing research with analyzing what customers wanted, what customers were interested in, what other stakeholders thought we should do. So we had to gather a lot of that information. Once we got to that, we then contracted out with Concentric to do some analysis based on the directives we were given, as well as the findings from our stakeholders and customers to then identify potentials for a new time of use period. That took several months for them to analyze. Once they had determined the analysis that they had provided and they're part of this testimony, and based on all the prior information, we decided internally with evaluation that we probably better look outside. And that's when we started that process. So yes, there was a lot of work leading up to the September date of a system integrator. And you can see some of that information in the final rate plan, as well as in the testimony that has been provided.
Okay, thank you. That's helpful.
May I add an external perspective to this, being a consultant that the company engaged? They did not receive in their, from their perspective, a very favorable decision in 220808, which also included some unfavorable aspects having to do with rate design. So upon receipt of that decision in August of 2023, they re-engaged us to help not only address those shortcomings that were clearly identified in the multiple directives in that PURA decision, but also to take head-on the directives for time of use pricing. And not only myself, but also several of my colleagues, some of which are here, some of which are not here, formulated a pretty broad team. And it was a very data-intensive analysis for several months, well before the application for this instant case was filed. And so I think it's difficult for us to sit here today and say, way back then, we should have known that, hiring a system integrator would have been a smart thing to do. I think it's been a very broad process with a lot of work, a lot of soul searching, both on, TOU, rate design, physical assets that the company has. All this stuff is integrated together, and it's been a heck of a process, and probably one of the more difficult engagements that I have personally been involved in for rate design. So I just wanted to kind of add that perspective that you may not see all of the work that's kind of led up to where we are here today. But I just wanted to share that with you.
Great, thank you. I appreciate that. I understand and can appreciate the complexity. Thank you. There was a several months delay between determining you needed the system integrator and then your initial proposal for when you thought the RFP would be issued, and then it was issued, I think, April 28th, you said. So that was about 4 months after the initial estimate. If you could speak a little bit about what led to that delay in issuing the RFP.
When we put together the timeline, we did put together starting December 9th, 2024. And we followed through the steps. The step 1 completed, and then step 2 completed. And we are halfway through on step 3. And we're still keeping our 45 weeks timeline as the final and deliverable. So overall, yes, we made some adjustments because of our internal processes and make sure we have a PM available. We follow the checks and balances, the procurement process. We're still within our 45 weeks overall delivery plan.
And you said the initial round of responses to the RFP are due next week. Do I remember that correctly?
Monday. Yeah.
Okay. And I think the most recent estimate from EOE 179, there's a chart.
Yes.
In that response, has the system integrator analysis and assessment covering about 15 weeks of time. Do we anticipate that's going to remain the estimate?
Yes.
Yeah, okay. And this is an obvious question, but I just want to make sure that we are all talking about the same thing. So in EOE 95, I just want to be clear that the system integrator is the consultant that you refer to. Okay, great.
Yes.
Okay, thank you. And I think that you said in response to an earlier question that you, because I was going to ask you what your proposed timeline is now, but I think I heard you say earlier that you don't have an updated timeline at this point in time because you haven't hired the system integrator yet. Is that right? Okay.
Yes.
And I think you also said you don't know when you will have a proposed timeline.
We said Q4 2025, we will have a updated proposal in
Okay.
for the implementation.
Okay. Thank you. And that, would the same be true for the estimated costs? I believe in response to EOE 93 in that same chart, the estimated costs for the system integrator totaled $276,000.
This is what we estimated. We won't know until we see the proposals back next week. So that's the final number.
Okay.
We will know, yeah.
All right. And I think that was information you said that if you had updates, you would file it in LFE 76.
Correct.
Okay, great. Thank you. Okay, my next question is regarding EOE 129 and EOE 134.
Said one,
Yeah, I was gonna say, just,
129. Oh, go ahead, Mr.
I was gonna say, just to level set, Mr. Patterson sponsored EOE 129, and he was present on the customer service and experience panel, but perhaps we can see where the question goes and see if this panel can help.
Yeah, I don't think you actually need either one of the interrogatories, but I wanted us to all be on the same page. So why don't I ask the question and then we can, okay. So in response to EOE 129, the company lists a web page in attachment 1 at page 64. That may be something you want to pull up. I'll tell you what it says though. This is a web page for time of use rate RT on the company's website. And it says that the company cannot estimate whether rate RT will reduce customer electric bills because the company does not measure electricity usage for rate R customers. And then in EOE 134, the company references Exhibit UI SIP 8, which is the final AMI plan. And at page 13, under analysis of customer usage, the company states that it can measure and has measured electricity consumption in 15-minute intervals with AMI meters for customers on rate RT. So my question is, can the company measure the customer's usage on a 15-minute interval with AMI meters when the customer is on rate R?
Yes.
Okay, so the company can, but currently it does not.
The company is currently collecting 15-minute interval data on 100% of its AMI meters.
Okay. So,
So I think, I'm not sure if where the reference came where it said we do not. I'm unaware of where that was or why it was stated. But at present time, our AMI meters are collecting 15-minute interval data.
okay, so I think this goes into LFE 77 where there was going to be a discussion or information about shadow billing, right? Customer rate comparison. So I think what I'm hearing you say is this is something that could be, there's a possibility that it can be done because you can measure usage for rate R and rate RT, provided the customer has an AMI meter.
I can jump in here for a moment. We have for many years now provided customers who are, who ask, who call up, and who have AMI meters, but it's a manual process where we compare their radar consumption to what the rates, we price it under what rate RT would have been. That's a manual process right now. And we have done it, and we do it when someone calls in and asks for that analysis. There is not an automated procedure to do that at this time. That may be coming in the future, but if this was something that we need to do for customer service, if someone calls in, then we can do it. We have the data to do it. We don't have the process to do it automatically.
Okay, so maybe the website linked in EOE 129 attachment 1 is an older.
It may be because the ability to do that has been just enabled in recent years.
Okay, thank you. That's helpful. Okay, this is my last question. It refers to OCC 844 and OCC 845. So it relates to what the company refers to as its comprehensive communications plan for customer education regarding time of use.
Said OCC 844 and 845.
Yes.
Again, I note that these were co-sponsored with Mr. Patterson, but we'll do our best.
In the response, the company states that it cannot provide details of its communication plan because it has not yet received detailed guidance from Pura. So I was hoping that you could expound on the detailed guidance from Pura that is necessary to develop the company's time of use communication plan.
I helped sponsor that, so I can answer that. Yes. We need to tell customers specifically what the time of use rates are, how they're going to be structured, what the hours are, and what the prices are, before we can go out and explain to them what's going to happen to their bills. We need an authority order to do that.
Thank you. Would it be fair to say that the information that you need is mostly around what I'll call the numbers, the rate, the hours?
Yes, it's all about that.
Okay, thank you. That's all my questions.
Thank you. Let's move to cross. I believe NECTA waived, so deep BETP. Yes, Attorney Nigro, please. Attorney Nigro, but your microphone, I think. Thank you.
Good afternoon.
Good afternoon.
I'm Susanna Nigro on behalf of the Department of Energy and Environmental Protection. I'm going to be brief. I just have a couple of questions. Could you please provide a brief description of UI's history with time of use rates, specifically the short period of mandatory time of use rates for certain customers?
Yes, from an authority order in a previous rate case, I think it was Docket 050604 RE04, we were required to put residential customers onto rate RT if they reached or exceeded 2,000 kilowatt hours during a monthly billing period. So during that time, there was probably somewhere between 30 to 35,000 customers who were mandated from rate R to rate RT and were required to stay on rate RT.
Okay, thank you. Switching gears, do time of use rates have to be higher in the summer? And if so, why?
Well, this is a summer peaking utility, and typically that means that there's capacity used in the summer that's not used throughout the rest of the year. It's idle. So if we want to price as to its utilization, then that requires the summer rate be higher because we're collecting costs for plant that's only used during the summertime.
And is that part of making the rates revenue neutral?
Well, that's part of, the rates are going to be designed to be revenue neutral, and they go where they have to go to maintain that neutrality. In this case, with a summer peaking utility, they're typically going to be higher in the summer because there is equipment that's used only in the summer and not used for the rest of the year. So,
Or stated, if I may jump in, stated differently, it follows cost causation to charge a higher rate in the summer when the assets are being utilized.
Thank you. Do you have an opinion on the likely customer reaction to higher summer end state rates?
we have not asked that specific question in a customer survey.
Okay. Thank you. That's all I have.
Thank you. Net speed. Attorney Goodman.
Good afternoon, panel. My name is Jay Goodman, and I'm appearing today on behalf of the Connecticut Industrial Energy Consumers, or CIEC. To begin with, please refer to Exhibit UI RP 11, which sets forth the company's proposed policy for special contracting. Regarding this policy, the company discussed what rates and charges could be discounted under a special contract, correct?
Correct.
In that context, the company stated that the System Benefit Charge, or SBC, would not be eligible for an economic development rate or EDR discount, correct?
Correct.
And the company similarly stated that the NBFMCC would not be eligible for a discount, correct?
Correct.
Thank you, Mr. Kolka. Do you recall Mr. Kolka sponsoring testimony regarding the design of an economic development rate and a low-income discount rate in docket number 171203 RE11, specifically filed on April 26, 2021?
I recollect it, but not specifically. I mean, I would have to refer to it to remember stuff.
Sure, I actually have a copy, if I could provide it to the witness to refer to, Attorney Vaughn.
Yes, you can provide it to him. He can refer to it. He may take some time to review it and answer your questions, but we appreciate that.
Understood.
Appreciate the courtesy copy.
Sure.
And well, my colleague refers, you said it was 17 something something REO 11?
Exactly, yes.
Thank you.
It was 171203 RE11.
Thank you.
Mr. Kolka, while you're refreshing your memory, I'll start with a question on page 5, if you'll let me know when you're ready.
Yeah, I'm there.
If you look at the first question at the top of page 5, it asks what electric services could be discounted through an EDR, correct?
Yes, I believe that we revised that viewpoint through the AMI docket in later through, oh, no, wait a second. What could be discounted through an EDR? This, I think we revised our viewpoint on this by researching the statute, because the subject to check, the statutes do specify that all customers shall pay this amount. We'll have to find the actual state statutes on that. But they're,
Understood. Would you be able to provide the specific reference to where you revised that opinion? And just for the record, since we didn't read the answer, it states that the SBC and NBFMCC could be discounted through an EDR.
those were our initial comments back in 2021. Yes.
Understood. If I don't know if that would be a read-in or an LFE, but if the company could provide that reference as a follow-up.
Right. So my colleague has just showed us some, this was testimony in, oh yes, in here, right in RP 11. We went through and we looked at these statutes. So, all right, that the system benefit charge is not eligible to the statutory requirement that all customers pay this charge is Connecticut General Statute Section 16245. I believe that's L. System B, the system benefits charge shall be imposed beginning January 1st, 2000 on all customers receiving service under a special contract which are entered into or renewed after July 1st, 1998. I did not realize that when I wrote these comments in 2021. That's right in the statute.
Understand. So your position is that the statement that the charge shall be imposed on every customer also means that it cannot be discounted for any customer.
Correct. That's our interpretation of that statute.
Would you please turn to page 9 of the same testimony? The second question from the top of the page. In response to a question regarding the appropriate discount that may be allowed for a low income discount rate, you answer that the rate, quote, need not be based on cost of service as the discount is targeted to a specific group of customers to satisfy a public policy goal. Would you agree that by the same reasoning, the authority could decide to approve a special contract discount for load retention that is not cost-based because the discount would serve a public policy goal?
Yes, if it's a line item credit and not a discount to the rates. See, how the LIDR works is that it's a discount to the entire bill. It's not a discount on any rate component. And that discount is recovered through the non-bypassable FMCC as an expense. So in that case, they're paying the rate, but they're getting a discount overall that's recovered from other customers.
I see. So your distinction is that it's simply a discount applied to a number of the total bill, as
Correct.
opposed to discounting the individual rates and charges within it.
Absolutely.
And to be clear, did I hear you say that the same approach could be taken for special contract and economic development rate for load retention?
If approved by the authority, then, but that may need to be something that's in a brief, because I can't make a legal opinion on that. I can just interpret it from a tariff standpoint. From the tariff standpoint, this is how we interpreted it.
The statute you just read a moment ago, is that not a legal opinion about whether or not the rate could be discounted?
I believe a moment ago, Mr. Kolka was reading from the RP 11, which provided a citation to the statute as a basis for help form the company's position, but I don't believe he was offering like an interpretation of the statute. I mean, we're trying to keep him on the facts. So
From a tariff standpoint, it appeared that we would be ineligible. We would be unable to do that. And that was our testimony here.
Okay. So the company proposed a price floor for special contracts that would determine the maximum discount that the customer might receive. And specifically, the company proposes to use the long-run marginal distribution cost for distribution substations and feeders, correct?
Where are you referring that to?
Just a moment.
Is that section 2.5?
Yes, price floor, section 2.5.
Yes.
And the company stated here that will seek to negotiate a discount that results in local delivery revenues which exceed the long-run distribution marginal costs so that the applicant pays towards the recovery of fixed costs, correct?
Correct.
And am I correct that payments towards the recovery of fixed costs also contribute to the company's margin?
It would be that over what the long-run marginal cost to provide the service, substation and feeder services. So there would be some contribution to other fixed costs.
Not to confuse the issue with the use of the word margin, but in the context of that term, long-run marginal cost, the word marginal means incremental, correct?
Correct.
Would you agree then that the utility's long-run marginal costs represent the cost of adding a unit of load to the utility system?
A unit of capacity, the cost of adding a unit of capacity to support the load, yes.
Okay. Right. It represents investment in capacity to serve the incremental load, correct?
Correct.
Okay. Would you agree that the utility also incurs short-run marginal costs to serve a customer?
The short-run marginal costs of the distribution system are essentially zero because the plant is fixed in place.
Does the company not have any variable O&M or other costs that would be considered short run?
Not necessarily related to changes in load. The large The large variable cost has always been fuel, and the company no longer has fuel costs because it no longer owns generation. Or said another way, the company does not incur additional costs on the distribution systems to serve an additional load, an additional kilowatt hour.
For an existing customer, though, does the company incur short-run marginal costs?
Not short-run energy costs. It does not cost the company from a distribution standpoint. It does not cost the company additional money to serve an additional kilowatt, to transport an additional kilowatt hour.
Okay, I'm not sure if we're talking past each other because I'm not asking about now that incremental load that might be served, but the, say, existing load of a customer. So trying to distinguish between the existing load of a customer versus some additional increment of load that that customer might start using. Does that change your answer?
No, if we look at say a radar residential customer, it could be any customer. They could have a load factor of 0 or they could have a load factor of 100. And the amount of kilowatt hours per unit of capacity that they use will then determine how many kilowatt hours they transport over that unit of capacity that they're using. It doesn't matter whether they use it for 1 hour a year or all hours a year. They're using that unit of capacity to transport the energy. It does not cost the company any money for a customer to go from, say, 50% load factor to a 51% load factor, or even from a 0% or 1% load factor to 100% load factor on the distribution system. The plant is fixed in place. The system will have to respond to changes in KW, not KWH.
Okay, just try to make sure I'm understanding. You're saying that the company doesn't incur any short-run variable costs to serve a distribution customer?
Not on the distribution system.
On the transmission system?
Not on the transmission. Well, no,
Where-
not on the transmission system, but that's not, I don't think that is relevant to the discussion of special contract because that's for jurisdictional. And that's a whole different set of conditions and rules.
I understand. When you were emphasizing not on the distribution system, I was simply trying to ask where then the costs are incurred, if you could explain
The
that.
costs are for short-run marginal costs. Those are variable costs are primarily incurred for fuel in the generation market.
If I could maybe try to help, and of course, Mr. Kolka, keep me honest, I think Attorney Goodman, what my colleague is saying, if I understand correctly, is if we have designed the distribution system, and I'm just going to use the illustrative example where there is just one customer using 1 kW of demand. If I'm understanding my colleague correctly, I think what he's saying is the number of kilowatt hours that customer uses won't change that fixed cost of providing service as long as we've constructed the system to support that capacity appropriately. So I think it might be your use of the word load that's causing us to talk past each other, but I think that's what is getting at. The emphasis of on the distribution system, I think, is an emphasis towards capacity, not saying, oh, that's going to create costs in transmission, if that helps.
I think so. One more question, and if the answer is the same, because I'm just being dense here, just tell me, of course. If we're simply looking at an existing customer who's not changing their demand, does the company, maybe two-part question, one, incur those short-run variable costs to serve that customer? And two, well, let's just start with that.
If the incremental use requires additional capacity, additional KW, then the company will incur a cost. But that's not a short-run cost.
Are the short-run marginal costs, the utilities variable costs
They are, yes, but they are fuel costs.
that you said you no longer incur because you
We
said
no
that's
longer incur fuel costs. We provide default generation service, but that's a bundled product that's in the supply markets. That is not anything that the company actually physically provides. As in the fully integrated days before restructuring, then yes, the company would have incurred those short-run marginal costs or variable costs to, they were primarily fuel and purchase power costs.
Okay. So returning to the proposal to set the price floor at something around the long run distribution marginal costs. If the special contract is for an existing customer for the purpose of retaining its load on the system, the load retention customer would not be increasing its demand under the special contract, correct? The purpose of the contract would be to retain load, not to increase it.
At that moment, is the question regarding why we chose the long-run marginal cost as the floor?
The question I was trying to ask is, the company through the last case now has an economic development incentive rate for new load, new business coming in, for example, for incremental load, an existing customer that's expanding its operations and is increasing its load or demand. The special contract is to be available under certain circumstances to retain load, correct?
Correct.
So the customer may not be increasing load, simply trying to keep it at a constant, correct?
That's correct.
Approximate constant. So in that circumstance, under the special contract, if the customer is not going to increase its demand under the contract, then the company would not incur incremental capacity costs to serve that customer, correct?
To keep serving, are you saying
To
we would not,
continue
to
serving the
keep
existing customer.
serving that load? No, correct. We would not.
So if the long-run distribution marginal costs is referring to an incremental cost of, the cost of incremental capacity to serve, but the company is not incurring any incremental capacity to serve that existing customer, then why did the company pick that?
Well, that's the crux of the reason that we put the price floor in at that is because going forward, if we retain that customer and there is load growth, then we want to make sure that that customer is paying their fair share of the load growth of what they are using. Because if we retain that load, and let's just say you've got a circuit that's 50 megawatts and there's a 10 megawatt customer there. And so if we lose that load, now there's 40 megawatts on there. If we keep that load, there's 50 megawatts on there. But in the future, as there is load growth on that circuit, eventually there comes to be a point where one would need to add capacity to it. And if we get to that situation where we need to add capacity and there's a customer with a special contract that is paying below that amount of incremental, of what it costs to add that incremental capacity, then the capacity that we saved by the capacity that would have been there available is no longer there because that customer is still there. Then we have to build. So it's a forward-looking floor such that keep that customer there. We have to assume that the special contract is going to go on indefinitely or is going to go on to a point where, yes, there could be load growth where that customer is. And if there is load growth where that customer is, we felt that it was not appropriate for any customer to be paying less than the incremental cost to add that new capacity.
So you picked a price floor to address a circumstance that might or might not occur in the future at some indefinite point in time?
Essentially, yes, because it could happen. Load growth does happen.
It happens not necessarily on the circuit or the asset serving the retention customer, correct?
Correct.
It could happen
We
anywhere.
wanted, we set it so that we would avoid the situation, however, whatever the chance of that is, that there'll be a customer paying below the incremental cost to put that plant in service.
So moving to section 2.6, the application process and discount determination. The company proposes to analyze profit and loss statements from companies that apply for the special contract to determine the applicable, determine if they should get the contract and what the discount may be. Will you explain how the company would conduct the analysis to determine whether it thinks that a special contract is warranted based on profit and loss statements?
Conceptually, we need to know that and this is all designed to eliminate free ridership, because it's possible that free riders could come forward and say that they're going to leave the system without actually any intention of leaving the system. I'm not saying that people would do that, but if we don't write a rule to prevent that, there's nothing from the, that almost encourages that to happen. So with this profit and loss statement, we want to see that this is really a load that that company cannot sustain any longer, and that it really needs to pull up stakes and move out or lose its business. Because if it's making money, why should they get a discount? Because that discount is going to be paid for by all other customers. We need to have some kind of measure to make sure that the assertion that they will no longer be able to be a customer is relevant and true.
I understand you're saying the point is to validate the claim.
Is to validate the claim, absolutely.
And to the question of how the profit and loss analysis would be used, did I hear correctly you say that if UI were to determine that the applicant was making a profit, then you would not grant or not propose a special contract?
I think that is probably the case. Perhaps that, Mr. Therian, have you seen these in other jurisdictions?
Yeah, economic development contracts or tariffs are prevalent throughout the country, and there are thresholds that must be met. Midwest, I've seen contracts out in the Midwest, and generally speaking, they're brought before the state authorities for approval, and ultimately the state authorities approve them.
So coming back though to, again, the statement I heard that if the applicant was found to be operating at a profit, some profit, that the company would not propose a special contract. It's the company's position then that an organization does not need financial relief unless it's operating at a loss?
No, we have to look at the specific facility and to see if it's viable in the location where it's at right now, or whether it's not viable. And, that we can only ascertain that or estimate that by seeing the numbers. If it is operating at a profit, by what's the virtue of giving them a discount that is being paid for by other customers? That's what we have to wrestle with. And perhaps it should not even be the utility that approves these. As Mr. Therian said, maybe these special contracts they are approved in other states by the regulatory authority. Perhaps this should be by the regulatory authority here. Or does the utility have to make the Solomonic decision about whether this customer needs a discount to stay on the system, and that will be paid for by all of the customers?
There could be multiple reasons why the load might be at risk, correct?
There could be many different reasons, sure.
And one of those factors could be a substantial factor, would be the cost of electric utility service, correct?
Absolutely.
Are you aware that a company may have facilities in multiple jurisdictions?
Yes.
Does the company have any experience or expertise or understanding of how those decisions are made when a company is looking at whether to continue or expand or shrink operations in a particular location, how the decision is made to do that, like that comparison across facilities where the evaluation includes a look at the operating costs, such as the price of utility services, which for a large user, large high load factor user is going to be significant.
Yeah, that makes sense.
Is that something that you would also be looking into as part of your analysis of the profit and loss statement?
I think similar to fuel switching analyses done in previous years, I think we'd have to look at competitive alternatives.
So if a competitive alternative can be demonstrated, that's additional information aside from the profit and loss statement that could be considered.
Yeah. I'm going to pass this over to Mr. Horowitz.
And I'll just say a couple general things, then I'll invite my colleague to weigh in, and you're of course free to bring us back to some of the specific details. We understand the impetus for offering an economic development rate broadly. We understand it's attractive to customers if you can bring on a new customer who's going to pay revenues into the system that exceed the marginal cost of that customer, even if those revenues are at a discounted rate relative to regular rates. And we further understand that the logic of that thinking also applies to the possibility of a load retention agreement. If we are staring down the prospect of losing load, losing capacity, and we're able to offer a discount to keep it, we understand the appeal to customers for that same reason. However, as my colleague, Mr. Kolka, described, and as UI described in docket number 220808 in the rebuttal testimony of the rates panel and was quoted by Pura in the decision to some extent, there's significantly greater risk of free ridership with a load retention tariff than there is with an economic development tariff. If someone comes to us and says, trust us, we're going to leave if you don't give us this discount, that's much more prone to people taking advantage of it. And so we have expressed concern at offering such a rate. And subject to my recollection, we recommended against offering one in 220808. But we were required to put together a policy, and this is the best policy we could put together based on the guidance that we've received. You know, I think the types of questions you're asking, what alternative fuels are available to a particular customer? Are electric costs going to be the make or break item that gets them to stay or leave Connecticut? Do they have another facility that they could jump to, maybe in a neighboring state? Of course, as a utility that has complained about our earned ROE, we understand calculus like that. But I think we've expressed that this is going to be a difficult analysis to undertake. This policy is our best effort to get at the types of things that you're highlighting, and we're open to further guidance or feedback as to how to further retain this. I think that the types of considerations that you're flagging make sense to me, but I think it also makes sense to me that these are going to be very difficult determinations to make with authority, with perfection. And so we've described the types of data, the types of evidence that we think would help us make that decision, but we stand by all the concerns we expressed in 220808.
We understand the concerns, and CIC has not argued that there should be no validation of the claim. So just two more questions on this point before moving on. First, just to clarify again, what I'm hearing is the company is saying that it would look at multiple pieces of information, if you will, multiple sources of information and data in making the determination and not rely solely on financial statements, correct?
I think this policy is written in such a way as to allow circumstance-specific considerations. You see, we request an affidavit in addition to profit and loss analysis. And I think to the point of your questions, that the phrase profit and loss analysis is in and of itself, it leaves questions. But I think that's appropriate given the ambiguity of what we're trying to ascertain. And I think the kinds of questions you've asked us sort of illustrate why it would be very difficult to come up with a one-size-fits-all for this.
Right, I appreciate the thorough answer, Mr. Hurwitz, which I believe was a yes plus a lot more.
Yes plus is a fair characterization.
And one other point to clarify, because I think I heard different answers, so just want to make sure when looking at the profit and loss statement, if in your determination by looking at the financial statements, the facility is profitable, that's not going to be determinative of whether or not it might qualify for a special contract.
Let me just check with someone before I give an answer that differs from the people who would actually administer this. One moment.
I think this is part of the evolution.
No, our intention is not for any income at all to disqualify you from this. Obviously, UI itself has earned income and complained that that was not enough. So that would be a hypocritical stance for the company to take.
Okay.
When we were developing this, we had no specific guidelines to developing this. This is a new service. It was terminated many years ago. Special contracts were terminated many years ago. They're coming back now. I think that we all have to learn about how these should be written and how we should be able to prudently make these contracts to retain load without running or minimizing the risk of free ridership. So, I mean, I think we are open to looking at different ways to go about doing this. This was the initial design of it, but certainly we don't want to dig into someone's sensitive financial information that they would have to release and have other competitors find out. We just want to make sure that we are not going to give an imprudent discount.
Okay, thank you for the additional explanation. If we could turn to section 1.2 eligibility for a moment. The company states that the intent of the special contract is to retain existing sales that would otherwise be lost due to customers moving out of UI service territory or going out of business due to the cost of electricity. I believe the company acknowledged that it included this policy proposal based on an authority directive coming out of the last rate proceeding. But that directive did not require the company to condition eligibility for a special contract on whether the need for such agreement was due to the cost of electricity, correct?
No, my recollection is that the authority asked us to develop or required us to develop a special contracting policy.
I'll just note that the cost of electricity is the only variable of that business that we as UI would be able to control. So if that's not a factor for the business, I don't know that the load retention tariff would be a good fit for that customer.
You can control the cost of delivery service, correct?
If you're interpreting the cost of electricity as like the cost of power supply, I would amend my answer. I was referring broadly to the cost of electricity, not delivery specifically, or distribution specifically.
Commodity versus distribution service, correct?
We can't do anything about the commodity.
Well, I understand. That's why I'm focusing on this particular part of the proposal, because the economic development rate incentive for new load and for incremental load provides a distribution rate discount. And it's the cost of that electric distribution rate that these customers are looking for relief from. So to condition a potential special contract on an impact from the cost of electricity that the company can't control seems odd. And so now, given the answer, I just want to clarify, Attorney Fawn, if I could just clarify based on what I've heard so far, the proposal is to condition special contract on a company potentially losing the load due to the cost of commodity.
If I could
No.
just.
With that's going, once again, this is an unbundled market. So the customer, our belief is that customers are not going to look at each individual component when they're making their decision. They're going to look at the cost of electricity, which includes all these other components, many of which we have absolutely no control over, and some of which we have some control over. Distribution, we can manage the expenses to our revenue requirement. But there's other costs there's other components in the cost of electricity that the customer faces. They don't get that service from us, or it's a service that is a public benefit they have to pay for. We think that they have to pay for. We can only work on a discount for that portion that is, we believe, distribution. And for these reasons that we've put out through here. So everything we have to do, everything we can do, everything we can set the customer to respond to is all through the distribution price. They still have to go out and get the rest of their stuff.
And I'll add just two extra comments for your consideration. I think first, which you may not like, but we have just one lever to pull here, right? This discount. And I think what we're trying to get at in this section 1.2 eligibility is pulling that lever going to make a difference for our customer? And if pulling the lever is not going to make a difference, if pulling that one lever that we have is not going to be the difference between that customer staying or leaving in the service territory, I think the calculus flips from what I said earlier about the overall justification for offering an economic discount rate. Then I think we're just giving money away for free, and that's not the best interest of all of our customers. The second point, though, which you might like a little more, is I think why did the one straw break the camel's back? It's all of the other straws underneath it. So if this customer is experiencing, or if a hypothetical customer were experiencing financial strain and the cost of electricity, i.e. the piece of the bill that we can control, is a material item for them, then I would expect that they would be able to point to that factor in satisfying this eligibility criteria. But I think it's important to have this criteria for the reason that I said. We want to minimize free ridership. We want to make sure that the discount is actually going to make a difference for all the reasons that my colleague, Mr. Kolka, said, and that we said on the record in the last case. But I also think if the hypothetical customer has a collection of costs, but then they can show that offering this discount on the one sliver of the bill that we can control will make a difference for them, I would expect that to be factored into this analysis.
I understand, but I'm actually asking a very, I think, narrower specific question. I think this discussion highlights what might be just a semantic issue. When I read the cost of electricity, to me, that means the cost of the commodity or the supply, as distinct from distribution charges. What I'm hearing from the company is it sees that word differently. Would you clarify what the intent of saying due to the cost of electricity is? Specifically, are you referring to the commodity? Are you referring to the distribution charges or something else?
Referring to the bundled cost. The customer faces the bundled cost.
Okay. The point is important because as customers are applying, if a customer, it's possible if this goes through, then no customer will apply because they won't need it. But if someone does apply, it's critical for these details to be clear. Because are you aware, for example, that to my knowledge, most, if not all of your large customers procure their commodity from a third party?
Yes.
And to your knowledge, are they likely doing that because they can buy the commodity more cost effectively or more inexpensively than they could get it from the utility?
We assume that's the case, yes.
So although they might be looking at the bundled package, their concern for going to the utility for some relief to retain the load is probably, would you agree, more focused on those distribution charges?
That's all, well, yes, because they would not come to us for their supply.
Okay.
Would you give us just one moment, Attorney Goodman?
Sure.
I'll just note for the attorneys, we are going to stop in 8 to 10 minutes, and then we will I'll poll everyone on remaining cost cross estimates before we break for the day.
While the witnesses confer, Attorney Goodman, I think you saw me look at you a while ago. I wanted to clarify that I believe, well, we ultimately did get to a question in some of your questions. There were some compounding statements and factual assertions, and I think that the witnesses have endeavored to answer the responses as the question as clearly and correctly as they can, but I don't want that to be construed as acceptance or admittance of any of the factual statements that you made sort of leading up to your question. Does that make sense?
Okay, I will take that as directed to the bench,
Sorry, yes.
and I will sustain that objection. Just to ask Attorney Goodman to make sure we're phrasing his questions.
Thank you, and apologies again, Chair Gillette, for not addressing that to you and rather to discussing that with Attorney Goodman. But
Understood. Thank you.
And Attorney Goodman, if it would be helpful, we'd be amenable to taking a late file to think through whether there's alternative language that we might be able to use, if that would be acceptable to CIC.
that would, and the offer is appreciated.
Okay, so that will be late file exhibit 79. And Mr. Hurwitz, can you just restate that for me, please?
To suggest alternative phrasing that could be used in exhibit UI RP 11, page 4, section 1.2 eligibility.
Thank you.
So if we can refer to page 13 of your direct testimony, beginning on line 4. Actually, let me go there too. Pardon?
The citation, the reference.
Oh, I'm sorry. Page 13, starting on line 4 of the rates panel direct testimony. Let me know when you're ready for the question.
I have that.
It's at page 13.
Correct.
There.
We're there. Thank you. Thank you. Here are the companies testifying that in its last rate proceeding, the authority provided cost allocation directives, guidance requirements that prioritized movement toward equalized class rates of return and fairness, correct?
Correct.
If all class rates of return were equalized, that would mean that each relative rate of return, or RR, OR, or index rate of return, would equal the system average return. Is that correct?
That's correct.
And that can also be described as moving the classes towards their costs of service, correct?
That's correct.
So if a class index rate of return is greater than 1.0, that means that the class is producing revenues that exceed its cost of service, correct?
Correct.
And conversely, if the index rate of return is less than 1.0, that class is producing revenues that fall short of the cost of service, correct?
That's correct.
So now on page 9 of your testimony, starting at line 21, the company testified that a cost causation approach to utility rate development seeks to minimize cross-subsidization between utility service classes, correct?
That's correct.
And by interclass subsidy, do I understand correctly that means that if you have a rate class with an index return greater than 1.0, meaning it's producing more than its class cost of service, that it is subsidizing one or more rate classes that are producing less than their class cost of service? Is that correct?
That is correct.
So at the risk of being redundant to recap, would you agree that a cost-based approach to revenue allocation would seek to move the rate classes towards equalized returns while minimizing interclass subsidies?
That's the ultimate approach. Yes.
And here the company testified that it believes it has proposed a class revenue allocation that moves towards the goals of equalized rates of return, correct?
I'm sorry. Could you just say that one more time? I don't.
Sure. Well, I'm looking at page 12, lines 15 to 16.
Page 12. It sounded familiar. Line 15 to 16.
We're on 15, basically on those lines, the company is stating that it's aware of Pure's directives.
Yes, sir.
And it has proposed a class revenue allocation that moves towards the goal of equalized
Yes, I agree.
rate of return. Okay. And again, that means that the allocation proposal should move the class returns towards 1.0, correct?
Correct.
The relative rates of return or index rates of return towards 1.0.
Correct.
Okay.
Closer to.
Right, move it towards.
Moving towards. Correct.
So if you could now refer to Exhibit UI RP3, which summarizes the company's cost of service study results. If you would let me know when you're there.
I'm there.
If you look at line 14, that shows the indexed rates of return at present rates, correct?
Correct.
And under column H, line 14, the index rate of return at present rates for the GST class was 5.2, correct?
Correct.
Would you agree this means that the GST class produced delivery revenues that exceeded its class cost of service by 520%?
Correct.
Same line, column I, so line 14, column I. The index rate of return at present rates for the LPT class was 5.28, correct?
Correct.
And similarly, that means that the LPT class at present rates is producing revenues that exceed the cost of service by 528%, correct?
Correct.
And based on the questions we walked through a few minutes ago, or just before this, the intent of the allocation is supposed to be moving those index rates of return towards 1.0, correct?
Correct.
Now, the panel did evaluate how its proposed revenue allocation would change the class rates of return, correct?
Correct.
And that is shown on lines 83 to 86. Is that right? Revenue to cost ratios.
Right. That's now understand that's different than the rate of return ratio. It's a different measurement. It's a similar measurement, but it's a different measurement.
Why did you use that measurement instead of an index rate of return?
The index rate of return is a little more, I guess, for lack of a better word, more volatile because it's really looking at the marginal return compared to the return on the system versus cost, which is the total cost of service. So I like to look at them both.
So the revenue to cost ratio is, you said, somewhat distinct from an index rate of return. However, it would be used in the same way where the goal is to move that number towards 1.0. Is that correct?
That's correct. So by way of comparison, you had just discussed this 520%. That's on a rate, that's a rate of return percentage. If you were to look at that on a total cost ratio, it's much less. But the point is still the same. If it's above 1.0, it's over collecting. If it's less than 1.0, it's under collecting. And you want to move towards parity or towards 1.0.
And here on these lines where it says revenue to cost ratios, you're presenting on the lines the revenue cost ratio for each class at present rates, at proposed rates, and the goal, correct?
Correct.
So if we look at line 84, column H, which shows the revenue to cost ratio for the GST class at present rates is 1.03, correct?
I'm sorry, just slow that one down a little bit for me.
Sure.
And I'll get there.
Line 84, column H for the GST class. So this would be the revenue to cost ratio at present rates.
1.03.
Yes. And
I'm
if
with
you
you.
go down one line, that would be the revenue to cost ratio at the proposed rates, correct?
Correct.
For the GST class, the revenue to cost ratio has increased from 1.03 to 1.22, correct?
Correct.
So under the company's proposed allocation, wouldn't you agree that the GST class would move away from parity?
Unfortunately, that's true.
And would you agree the same result is true for the LPT class, correct?
Correct.
And there I'm looking at the same lines 84 and 85, but now column I, where the LPT revenue to cost ratio would increase from 1.03 to 1.23.
Correct.
And the panel actually acknowledged this result on page 16 of its testimony, correct? Lines 8 to 9 specifically.
I'm sorry, page 16,
Lines 8 to 9.
Yes, I do recognize that, yes.
Okay. I have just a couple questions regarding rate design. If you would turn to page 28 of the panel's rebuttal testimony.
Attorney Goodman, is that a good spot to break for the
It,
night?
it is, I don't have much left, but this would be a good spot to break.
Much left as in 5 minutes, 30 minutes?
10 to 15, maybe. We could try to do a lightning round and get through in 10.
Yeah. I think I
I
have
can pick it up in the morning.
Yeah, I think I have I'll have a couple cleanups and then we'll have redirects. So we might want to go ahead and stop for the evening. And when we resume in the morning, it will be with the remainder of Attorney Goodman's cross for this panel. So Attorney Goodman, while I have you, I'm gonna poll people on remaining cross estimates. You've reserved 2 hours for the subsequent panel for OCC. If that's roughly correct or more or less.
It is not. That was a conservative estimate made a while ago. I think I actually need much less time. I'm not sure exactly, but I would estimate 15 minutes now, potentially less depending on what questions are asked ahead of me. If I remember correctly, I'm not the first.
Correct. I think authority staff are up first, and I do believe our estimate is correct. Page 17 panel has been excused by affidavit, I believe. I'm not showing any cross for page 19. But back on page 18, I had OCC listed as 3 hours and NECTA listed as 2 hours. I have reserved the right for the remainder. Attorney Wyman? $30 minutes. Okay. Anyone else with any updates?
Chair Gillette, we have reserved the right for the OCC's rate design witness and just to flag that we may have a few questions. I'm not sure yet. And I'm wondering if, given Attorney Goodman's 10 to 15 minutes left and your indication of having a handful of questions, would we know if any of those questions would relate to Mr. Pertel's area of load forecasting and the like? He recently had surgery and has a follow-up appointment and has to get back to New York at some point soon. So I was wondering if we could let him go rather than keep him overnight, but I don't want to put a box around anyone. So I just figured I would ask.
I have no questions regarding load forecasting.
I also do not, so he can be excused.
Thank you very much. And if anything comes up, we're happy to take a late file or deal with it as best we can, but we really do appreciate you bringing up Mr. Pertel.
Understood. Thank you. All right. Any administrative matters before we conclude? All right. Seeing none, we will see everyone back at 10 a.m. Thank you.